All right, Schaefer Cox was one of the ones who helped write the Articles of Freedom. It's a 63-page document. I wanted to read that into YouTube. This article here on freeschaefercox.com says, in an interview by Next News Network published April 22nd, 2014, Libertarian presidential nominee Michael Badnarik and Rick Wose shed light on Schaefer Cox. Many feel Cox was set up by the government to silence him from speaking out to the American people about the loss of freedom. Badnarik, president of 2009 Continental Congress, Wose, honorary Illinois delegate, and Cox met at the 2009 Continental Congress where the Articles of Freedom were drawn up. The Articles of Freedom are a list of grievances and solutions delivered to Congress by the American people. All right, here we go. We're going to read the Articles of Freedom. Restoring the Constitution for the free people of the United States of America. From the citizen delegates representing each of 48 states who convened for 11 days at Pheasant Run in St. Charles, Illinois to deliberate, debate, and decide a plan to restore constitutional governance in the United States of America. November 11th through 21st, 2009. Any portion or section herein may be reproduced in its entirety with no alterations or additions and shared freely with all peoples if credit or source is cited as the Articles of Freedom, the works of the Continental Congress 2009. www.givemeliberty.org. Call to action, go to www.articlesoffreedom.us, take the nationwide civic action pledge, join millions of others. Introduction. Think of the millions of folks, including members of armed forces, who have raised their right hand and said, I do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation of purpose of evasion, and that I will well and faithfully discharge the duties of the office of which I am about to enter, so help me God. Think of the millions who have placed their right hand over their heart and said, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. How could anyone who has pledged their devotion to the Constitution reconcile the following violations of the Constitution that are destroying America? When will it end? For decades, our government has been meddling in the internal affairs of other countries without any constitutional authority, causing foreign nationals to direct their hostilities toward us, which has given us a war on terror and a growing police state that is repugnant to the Fourth Amendment and the general welfare of a free people. For decades, we have had undeclared wars in violation of the War Powers Clauses of Article 1 and 2. We are now gifting and lending public money and credit to private corporations for decidedly private purposes, corporate welfare, without any constitutional authority whatsoever. We have a fiat currency in violation of the money clauses of Article 1. We have been emitting trillions of dollars worth of bills of credit through or under the auspices of the Federal Reserve System in violation of Article 1. We have been incurring trillions of dollars of debt for the payment of expenditures for programs and activities that are not enumerated in Article 1 and therefore not authorized. We have a fraudulently ratified 16th Amendment in violation of Article 5, a direct unapportioned tax on labor in violation of the tax clauses of Article 1, and a judicial system that refuses to consider the evidence in violation of Article 3. For decades, we have had unenforced immigration laws in violation of that mandate plainly worded in Article 2 that requires the President to faithfully execute all the laws passed by Congress. We have had a president whose father was not an American citizen in violation of Article 2. Amen to that. We are counting our votes in secret, as all machines do, in violation of our constitutional right not only to vote but to know that our votes are being accurately counted. We have had an absence of well-regulated state militias, and we have had federal gun control laws, all in violation of the Second Amendment. For decades, in violation of the Sovereignty Clause of the Declaration of Independence, the United States has been entering into treaties, contracts, and relationships with foreign entities, and giving authority to international bodies, dissipating, destroying, and undermining America's sovereignty. We have had private land being taken for private purposes in violation of the Fifth Amendment. We have a government about to become a provider of health care and about to order the people to purchase a product powers that are not enumerated in Article 1 and therefore not authorized. We have money bills originating in the Senate in violation of Article 1. We have a Senate that is using a supermajority vote to decide whether to enact law without an amendment to the Constitution, all in violation of Article 1, Section 3 and 5, and Article 5. These violations have challenged the constitutional republic of the United States and her people to its core. Above all, we have government officials who, for 14 years and more, have refused to honor their fundamental obligation to respond to the people's First Amendment petitions to redress these violations. I call this the capstone grievance. It is well settled in American jurisprudence that if anyone has an obligation to respond and he fails to do so, his silence amounts to admission. It is also well settled that any right that is not enforceable is not a right. That is, every right there is a remedy. However, the Constitution cannot defend itself. It is the duty of the people to defend it. The We the People Foundation exists for the purposes of protecting and defending our federal and state constitutions and to ensure the day comes when the American people will have institutionalized citizen vigilance for the purpose of routinely holding their elected officials accountable to their constitutions, regardless of their political stripes and whether they voted for them. The vision for Continental Congress 2009 came in December of 2008 while I was preparing to give a speech at the Faneuil Hall in Boston. The idea was well received. From January 1st to May 1st, I traveled to 88 cities in all 58 states to meet with people to see if this was an idea they would support and help make a reality. They agreed. On May the 21st, the foundation sponsored a meeting of leaders of the freedom movement at the Jekyll Island Club in Georgia. This was the place where the Federal Reserve was first conceived in 1910. We stood in the Federal Reserve Room, as it is called, and asked our Creator to put a new and righteous record for America in the place of what had gone before. We believe our prayers were answered. We discussed the Continental Congress 2009, and if this was an idea they could support and help make a reality. They all agreed. From June the 1st to October the 10th, a national structure was established to accommodate Continental Congress 2009. State coordinators in nearly every state volunteered their time and energy along with other citizens. A small national management team formed to assist. Delegates were nominated in each state to attend the Congress. A constitutionally correct election was held on October the 10th. On November the 11th, 2009, the delegates attended Continental Congress 2009 at Pheasant Run Conference Center in St. Charles, Illinois, sponsored by the foundation. The delegates of the Continental Congress 2009 were not professional legislators or wordsmiths. They were ordinary, non-aligned citizens from across America in all walks of life. They set aside their lives for this assembly. They represented you and me and the free people of America. The conclusion of their efforts, their recommended course of action to restore and maintain constitutional obedience in America, is this document called Articles of Freedom. It is purposed that these articles be distributed to all in the land with the intent to draw the attention and courage of a godly number of millions of people who, entitled to their freedom and essential to its maintenance, arise to restore and maintain the Constitution for the United States of America. Then and only then shall America's destiny be fulfilled. Please take the time to read the Articles of Freedom, learn about the Constitution, take the pledge to stand with millions of Americans as the Articles of Freedom are served on our elected officials, and then if necessary to participate in coordinated nonviolent legal and constitutional civic actions to stop the violations. Robert L. Schultz, founder and chairman, We the People Foundation for Constitutional Education, Incorporated, www.givemeliberty.org. Declaration and Resolves of Continental Congress 2009, page 6. In defense of a free people, the time has come to reassert our God-given natural rights and cast off tyranny. Let the facts reveal the federal government of the United States of America was instituted to secure the individual rights of our citizens and instead now threatens our life, liberty, and property through the usurpations of the Constitution. Emboldened by our own lack of responsibility and due diligence in these matters, government has exceeded its mandate and abandoned those founding principles which have made our nation exceptional. Our servant government has undertaken these unconstitutional actions in direct violation of their enumerated duties to the detriment of the people's liberty and the sovereignty of our republic. Over many years and spanning multiple political administrations, the people who have in good conscience attempted to deliberate our grievances and voice our dissent against their offensive actions through both petition and assembly have been maligned and ignored with contempt. The people of the several states of Alabama, Alaska, Arizona, Arkansas, California, Colorado, Connecticut, Delaware, Florida, Georgia, Hawaii, Idaho, Illinois, Indiana, Iowa, Kansas, Kentucky, Louisiana, Maine, Maryland, Massachusetts, Michigan, Minnesota, Mississippi, Missouri, Montana, Nebraska, Nevada, New Hampshire, New Jersey, New Mexico, New York, North Carolina, Ohio, Oregon, Pennsylvania, Rhode Island, South Carolina, South Dakota, Tennessee, Texas, Utah, Vermont, Virginia, Washington, West Virginia, Wisconsin, and Wyoming justly alarmed at these arbitrary and unconstitutional actions, have met as a citizen delegates and sat in General Congress in the city of St. Charles, Illinois. Whereupon we, as these citizen delegates, have gathered in defense of divine justice, liberty, and the principles of limited government, now stand in clear recognition of the supreme law of the land, the Constitution of the United States of America. Therefore, we demand that the government immediately reestablish constitutional rule of law, lest the people be forced to do so themselves, and we hereby serve notice that in the defense of freedom and liberty there shall be no compromise to which we shall ever yield. Prayer for Continental Congress 2009. Almighty God, on this day, the 11th of November, in the year of our Lord 2009, we turn our attention to Thee and those who minister with Thee to protect and guard this nation and the rights of free men. As we enter into these deliberations, we humbly ask for Thy guidance, illumination, protection, and peace, that we may know Thy will for our beloved United States of America and this Continental Congress. Give us the strength and energy and the courage to do what is right through this body. At all times, protect those who are gathered here, our loved ones, and all who are standing now for the rights of free men, not only in this time together, but as we move forward to fulfill Your plan. We ask Thee to enfold us in that which You know will enable us to carry on the sacred trust given by our founding fathers, through whom Thy voice was heard. We offer all we have or ever hope to be in this service for our country and fellow man. Unite us as one heart, one mind, one body. We give Thee all credit for all good that may come from our humble efforts, and we ask Thy great mercy and forgiveness for Thy wrongs which have been committed against the charters of freedom which Thou gave to this world through the American people. May we carry the torch of liberty, that all on this earth may one day know the gifts and blessings Thou intend for each of us. We offer this prayer to Thee, our Creator and nature's God, with a firm reliance on the protection of divine providence. Amen. Table of Contents. Introduction. Declaration and Resolves of the Continental Congress 2009. The Prayer for Continental Congress 2009. Article 1. Sovereignty and the Declaration of Independence. A. Affirmation. B. Remedial instructions to Congress and each of the several states. C. Additional remedial instructions to Congress. D. Additional instructions to each of the several states. E. Recommended civic actions by the people. Article 2. Constitutional laws and the Declaration of Independence. A. Remedial instructions to Congress. B. Remedial instructions to each of the several states. Article 3. Petition for redress in the First Amendment. A. Background and statements of the facts. B. Remedial instructions number 1 to Congress. C. Remedial instructions number 2 to Congress. D. Remedial instructions to the Supreme Court. E. Remedial instruction to the President. F. Remedial instructions to each of the several states. G. Recommended civic actions by the people. Article 4. Malicious firearms in the Second Amendment. A. Remedial instructions to Congress. B. Remedial instructions to each of the several states. C. Recommended civic actions by the people. Article 5. Privacy and the Fourth Amendment. A. Remedial instructions to the federal government. B. Remedial instructions to each of the several states. C. Recommended civic actions by the people. Article 6. Private property and the 4th, 5th, 9th, 10th, and 14th Amendments. A. Background and statement of the facts. B. Constitutional provisions. C. Energy independence. D. The Wildlands Project. Conservation of biological diversity. E. Remedial instructions to Congress. F. Remedial instructions to each of the several states. G. Recommended civic actions by the people. Article 7. Juries and the 7th Amendment. Background and the statement of facts. B. Remedial instructions to Congress. C. Remedial instructions to each of the several states. D. Recommended civic actions by the people. 8. Article 8. income tax, and the 16th Amendment. A. Background and statement of the facts. B. Remedial instructions to Congress. C. Remedial instructions to each of the several states. D. Recommended civic actions by the people. Article 9. Foreign policy and the general welfare clause of the preamble to the Constitution. A. Background and statement of the facts. B. Remedial instructions to Congress. C. Remedial instructions to each of the several states. D. Recommended civic actions by the people. Article 10. Money and Article 1 of the Constitution. A. Remedial instructions to Congress. B. Remedial instructions to each of the several states. C. Recommended civic actions by the people. Article 11. Public debt and Article 1 of the Constitution. A. Background and statement of the facts. B. Remedial instructions to Congress. C. Remedial instructions to each of the several states. D. Recommended civic actions by the people. Article 12. War powers and Article 1 and 2 of the Constitution. A. Background and statement of the facts. B. Remedial instructions to Congress and the President. C. Additional remedial instructions to Congress. D. Remedial instructions to the President. D. Immediate. E. Hold on. Let me back up just a bit. C. Additional remedial instructions to Congress. D. Additional remedial instructions to the President. E. Remedial instructions to each of the several states. F. Recommended civic actions to the people. Article 13. Eligibility and the Natural Born Citizen Clause of Article 2, Section 1 of the Constitution. Amen. Part 1. A resolution. Can't wait to get to that part. A. Background and statement of the facts. B. Remedial instructions to Congress. C. Remedial instructions to each of the several states. D. Recommended civic actions by the people. Part 2. A presentment. Article 14. Illegal immigration and the oath of office clause of Article 2, Section 1, and faithfully execute clause of Article 2, Section 3 of the Constitution. A. Remedial instructions to the President. B. Remedial instructions to Congress. C. Remedial instructions to each of the several states. D. Recommended civic actions by the people. Article 15. Ancillary report by the Foreign Policy and General Welfare of Committee regarding the welfare state. The assistance and protection of divine providence. Nationwide civic action and pledge. Okay, we'll start with page 11 here in a second. All right, let's try to get pages 11 through 20 of the Articles of Freedom. Article 1. Sovereignty and the Declaration of Independence. Affirmation. We the people, in order to maintain our independence from any oppressor, to protect our rights as free men and women, to secure the blessings of liberty for our posterity, and to document our resolve to resist any external or internal force which may seek to curtail those rights, make this affirmation. All sovereignty originates with the Creator and is gifted to the individual from where it is delegated to the family of the state, the state to the nation. Any corruption of this order violates natural law and the God-given rights of the people. Whereas all political power is inherent in the people, and whereas the natural rights of persons are unalienable, and any violation of those rights is cause for remuneration and or punishment, and whereas according to the Declaration of Independence the purpose of the government is to secure these rights, and whereas a government that has become destructive of these rights has abused its authority, and whereas history has shown that the further away governments are removed from the people, the more corrupt and oppressive they become, and whereas the officers of our governments have taken an oath or affirmation to support and defend the federal and state constitutions, and whereas the federal constitution is the supreme law of the land, and whereas certain unelected supranational bodies seek to usurp the authority of the United States Constitution, and therefore the actions of these bodies are incompatible with the liberty of the people of the United States. And there's a footnote down here. I'm going to go ahead and try to read it. Footnote 1. Learn more about the subject matter of this article in June 2008. Again, in August of 2009, every member of Congress and President were petitioned for redress of grievances relating the then latest unlawful and unconstitutional action by the government to undermine the sovereignty of the people, the states, and the Union itself. In this case, the attempt to create a North American Union. The people and the petitions were ignored. Read the sovereignty petition. See related CC 2009 video presentations. Tom DeWeese, Executive Director, American Policy Center, and First Delegate from Virginia, Sovereignty and the North American Union. Moving on to page 12. Whereas the Declaration of Independence declares man's rights to establish governments to secure his liberty and alter or abolish those which do not, and whereas the concept of exclusive judicial review of constitutionality is not to be found anywhere in the federal Constitution, and whereas the 9th and 10th Amendments to the federal Constitution clearly indicate that all powers not enumerated in the federal Constitution are reserved to the states or the people, and whereas the states are not ruling on constitutionality, it is the responsibility of the people as the final arbiters of the Constitution to decide on what is or is not constitutional. Whereas this body is a body made up of people who are able to instruct our servant government, and whereas we the people do not consent to supranational bodies which may or may not seek to become a world or even a regional governing body. Therefore, be it resolved that we the people do hereby declare ourselves to be independent of all supranational bodies, including but not limited to the United Nations and any subsidiary thereof, the International Monetary Fund, IMF, the North Atlantic Treaty Organization, NATO, any so-called free trade agreements, and organizations such as WTO, NAFTA, CAFTA, GATT. Any association or group which seeks to subvert the Constitution, such as the Council on Foreign Relations and the Trilateral Commission, and that we declare any treaties that these bodies create to be null and void. And be it resolved that we the people do not consent to tyranny, and we will actively resist any infringement upon our liberty as described in the Declaration of Independence, which has been secured by the Constitution of the United States, which springs from the stirring of our own hearts and souls. Be it further resolved that we the people reaffirm that our unalienable rights, as they are enumerated in the Declaration of Independence, which states in part that whenever any form of government becomes destructive of these rights, it is the right of the people to alter or abolish it, and institute new government, laying its foundations once again on the principles of liberty and freedom. We further affirm the right of the people to organize government powers in such a form that shall seem most likely to them to secure their unalienable rights, including but not limited to life, liberty, property, and the pursuit of happiness and self-governance, through the utilization of any and all means available to them. Be it further resolved that this body appeals to the people to secure their sovereignty by any and all means necessary. This body recognizes that if and when force is brought to bear on the people, it is the right of the people to meet force with equal force, be it from a foreign body or the misuse of domestic power. Any infringement on the liberty and freedom of the people as enumerated in the Constitution is an act of war against the people, and the people and their militias have the right and duty to repel it. Be it further resolved that this affirmation serves as notice to any and all would-be oppressors that the people's resolve shall not be questioned, and no person or group has the right to exert their will upon another. The strength of our convictions is deep and powerful, and these are tested at great risk to our would-be oppressors. If this tyranny is brought to our doors, then the consequences will be brought to theirs. B. Remedial instructions to Congress and each of the several states. Congress and the legislatures of each of the several states shall reaffirm the fundamental political and legal principles that: Bullet 1. The Declaration of Independence is the original and supreme assertion of the independence and sovereignty of we the people, and as such it constitutes as a great and indispensable charter and guarantee of our freedom and liberty. Bullet 2. The Declaration of Independence asserts that we, the people, have assumed among the powers of the earth the separate and equal station to which laws of nature and nature's God entitled them, and that the original 13 colonies took upon themselves the status of free and independent states with full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do. The purpose of the Constitution. Bullet 3. The purpose of the Constitution of the United States is to provide a charter for the government of the people of the United States in their separate and equal station that they have assumed among powers of the earth through the formation of a more perfect union among the states. Through this union, the sovereignty of the people is exercised through a federal government under the control of the people and for the benefit. Therefore, the Constitution cannot serve any international, supranational, anti-national, or merely private function that would infringe upon the right of the people to that separate and equal station that the Declaration of Independence guarantees them. Bullet 4. The Constitution of the United States as the supreme law of the land is based upon the principles of liberty stated in the Declaration of Independence. Therefore, the oath or affirmation taken by all government officials is at every level to protect and defend the Constitution also binds them to support those principles and in the Declaration of Independence. Therefore, no public office may lawfully take any action whatsoever that 1. Results in the surrender, alienation, or delegation of the sovereignty of the people of the United States. 2. By entangling alliances, special relationships, or through political or economic subservience, advances the interest of any other nation, international organization, supranational entity, or private organization at the expense of the sovereignty of the United States. Any such action is by a public official is a violation of that individual's oath or affirmation of office and is therefore treason against the Constitution of the United States of America. C. Additional remedial instructions to Congress. We hereby instruct Congress to repeal all legislation for which it cannot show constitutional authority under the enumerated powers of Article 1, Section 8. D. Additional remedial instructions to the several states. We hereby instruct our state legislatures to 1. Adopt state sovereignty resolutions that assert the power of the state to treat as null and void all federal legislation that exceeds the enumerated powers of Congress under the Constitution and to enforce such resolutions by the interposition of the state to protect its citizens from unconstitutional federal legislation. 2. Demonstrate principled leadership, strengthen the state's power to protect its citizens, and completely and forever eliminate the most common means of federal coercion by refusing all federal funds that are not specifically authorized by the Constitution. Encourage the true and proper general welfare of the state by repealing state welfare legislation, thus leaving the citizens free to build strong families, exercise true individual charity, and rebuild actual community through voluntary association rather than government coercion. E. Recommended civic actions by the people. Whereas federal violations of the General Welfare Clause cannot be truly reversed without a voluntary resumption of personal responsibility, we urge our fellow citizens to join us in promoting the true general welfare of the United States through the following citizens' actions. We call upon the people to 1. Break the chains of government dependence by refusing to participate in any unconstitutional government welfare program, whether the individual or corporate, including but not limited to Social Security, Medicare, Medicaid, grants, subsidies, or any other form of federal welfare. 2. Make informed choices regarding health insurance, vaccinations, mental health screenings, dietary supplements, medications, and other health decisions based on personal choice and not merely in obedience to intrusion and offensive federal laws, with a willingness to disobey such laws when conscience or reason dictate. 3. Seek out information about companies that use federal and state governments as their agents to rob us of our wealth, enrich themselves through bailouts, grants, subsidies, and other corporate welfare, and to communicate to them our refusal to do business with them while they persist in their thievery. 4. Refuse support to churches, religious organizations, and charities that denigrate our Constitution by availing themselves of unconstitutional government programs rather than voluntary charity. Instead of vigorously and generously support new churches and religious organizations that boldly stand for the principles of liberty enshrined in our Constitution, and additionally to build strong community structures on the basis of voluntary association rather than government coercion. 5. Refuse to give the federal government absolute control of our children's education while compelling us to pay for it, and to practice our parental rights by providing our children education at home through private institutions, thereby protecting them from harmful, dishonest, and subversive government indoctrination. 6. To live our lives as free individuals, not ceding any authority to federal government which we have not expressly granted it in our Constitution, and to disobey when appropriate any unconstitutional laws, and use every means at our disposal to challenge usurpations through the courts, political action, and any other means deemed necessary. Article 2. Constitutional laws and the Declaration of Independence. A. Remedial instructions to Congress. Whereas laws inconsistent with the letter of the spirit of the Declaration of Independence and the Constitution for the United States may be hastily and unadvisedly passed, be it ordained that here shall be listed the members of Joint Committee for Constitutional Governments shall be constituted a joint committee called the Committee for Constitutional Governments to review all bills about to be passed into law by the Congress, and for that purpose the committee shall assemble themselves from time to time when the Congress shall be convened. The size and funding of the committee shall be sufficient to allow the effective and efficient operation of the committee based on the annual review by and containing that recommendation of the General Accounting Office. All bills that have passed the Senate and House of Representatives shall they become laws be presented to the committee, which will identify and record in its minutes the provisions of the Constitution, if any, that authorize the parts of the bill and prohibitions or restrictions that would be violated. If upon such consideration it should appear improper to said committee or a majority of them, the bill should become a law of nation, and the committee return the bill, together with their objections thereto in writing to the Senate or House of Representatives, in whichsoever the same shall have originated, who shall enter objections set down by the committee at large in their minutes, and proceed to reconsider There's a footnote 2 here. I'm going to read footnote 2 at the bottom of page 15. Learn about this article, read Constitution and Declaration of Independence, see the related CC 2009 video presentations, Michael Badnarik, President, Continental Congress 2009, Keynote Address, Charters of Freedom, November 12, 2009, and Robert Schultz, organizer of Continental Congress 2009 keynote address. The Constitution does not defend itself and is not a menu. Moving on to page 16. Committee at large in their meetings and proceed to reconsider the bill if a provisions in any bill is found to be repugnant to the letter of the or spirit of our Declaration of Independence and or our Constitution. The bill shall be returned to the chamber where it originated together with its objections. The chamber shall publish the objections in its minutes and proceed to an up or down roll call vote accepting or rejecting the committee's report prior to any future action. If the bill passes the roll call vote accepting the committee's report, the bill itself would be voted on. If a majority of the members agree to pass the bill in spite of the committee's objection, the bill together with the objection shall then be sent to the other chamber, where the process would then be repeated. Up or down roll call vote on the committee's report, followed by the vote on the bill itself. And in order to prevent any unnecessary delays, be it further ordained, each bill shall be returned to the committee within 10 days. 1. Unless the committee notifies each chamber that it requires more time to complete its reviews, specifying the time required, but in no event shall the committee take more than 30 days to return the bill. Or 2. Unless the Congress, by their adjournment, renders a return of the bill within 10 days impractical, in which case the bill will be returned on the first day of the meeting of the Congress after the expiration of 10 days. Remedial instructions to each of the several states. Whereas laws inconsistent with the letter or spirit of the Declaration of Independence and the Constitution for the United States may be hastily and unadvisedly passed, be it ordained that here shall be listed the members of the Joint Committee for Constitutional Governments shall be constituted a committee to be called the Committee for Constitutional Governments and shall review all bills about to be passed into law by the state legislature, and for the purpose that the committee shall assemble themselves from time to time when the legislature shall be convened, the size and funding of the committee shall be sufficient to allow the effective and efficient operation of the committee based on the annual review by and including the recommendations of the Comptroller's Office. All bills shall have passed by each chamber of the legislature shall, before they become laws, be presented to the committee, which will identify and record in its minutes the provisions, if any, of the state constitution, the authorize the parts of the bill and the prohibitions or restrictions that would be violated. If upon such consideration it should appear improper to said committee or a majority of them, then that the bill should become a law of the state, then the committee shall return the bill together with their objections thereto in writing to the chamber in whichsoever the bill shall originated, who shall enter the objection set down by the committee at large in their minutes and proceed to reconsider the bill. If a provision in any bill is found to be repugnant to the letter or spirit of our Declaration of Independence and or state constitution, the bill shall be returned to the chamber where it originated together with its objections. The chamber shall publish the objections in its minutes and proceed to up or down roll call vote accepting or rejecting the committee's report prior to any future action on the bill. If the bill passes, the roll call vote accepting the committee's report the bill itself would then be voted on. If the majority of the members agree to pass the bill despite the committee's objections, the bill together with the objections shall be sent to the other chamber where the process would then be repeated by an up or down roll call vote on the committee's report followed by the vote on the bill itself. And in order to prevent any unnecessary delays, be it further ordained, each bill shall be returned by the committee within 10 days. 1. Unless the committee notifies each chamber that it requires more time to complete its review, specifying the time required, but in no event shall the committee take more than 30 days to return the bill. Or 2, unless legislature by its adjournment renders a return of the bill within 10 days impractical, in which case the bill will be returned on the first day of the meeting of the legislature after the expiration of 10 days. Article 3, petitions for redress and the First Amendment. A. Background and statement of the facts. The Constitution for the United States of America is being violated. It has been violated over many years by many administrations, by every branch of government, by each party. Much as our forefathers repeatedly petitioned the king for redress of violation of their rights, we, the people, pursuant to the last 10 words of the First Amendment to the Constitution, otherwise known as the Accountability Clause, have repeatedly petitioned the three branches of our federal government for redress of grievances. The people have petitioned in many ways over many years by many means, including by individual, informal, written, and verbal communication, and by countless formal proper petitions for redress of grievances. See attached petitions. Among the proper petitions filed are those related to meddling in the internal affairs of other countries without constitutional authority. 2. Undeclared wars in violation of the War Powers Clauses of Article 1 and 2. Footnote number 3 on page 17. Learn more about this article. See petitions for redress. See the petition for writ of Certiorari and Appendix to the Supreme Court of the United States, the unsuccessful attempt by the people to have the court for the first time in America's history define the meaning of the last 10 words of the First Amendment. See the related Continental Congress 2009 video presentation, Mark Lane, attorney, The Right to Petition and the First Amendment, and Robert L. Schultz, chairman, We the People Foundation for Constitutional Education. The top of page 18. Number 3. The gifting and lending of public money and credit to private corporations for decidedly private purposes, bailouts, without any constitutional authority whatsoever. 4. A debt-based fiat currency controlled by the Federal Reserve System, a cartel of private banks, all in violation of the money clauses of Article 1. Direct unapportioned taxes on labor in violation of the tax clauses of Article 1. 6. Invasion of privacy and developing police state in the violation of the privacy clauses of the Fourth Amendment. 7. Unenforced immigration laws in violation of that mandate plainly worded in Article 2 of the Constitution that requires the President to faithfully execute the laws. Number 8. A President who refuses every request to provide evidence that he is a natural-born citizen, as Article 2 requires. Amen, amen, and 10 amens. Amen to that. Number 9, the counting of votes in secret, as all machines do, in violation of the constitutional right, but not only to vote, but to know that all the votes are being accurately counted. Number 10, the absence of well-regulated state militias and the presence of federal gun control laws that violate the Second Amendment. And number 11, the government's attempt to merge the government of the United States, Mexico, and Canada into a North American Union. These petitions for redress of constitutional violations have been answered only with repeated injury. For instance, the petitions served upon officials in the executive and legislative branches have been answered only with silence, notwithstanding the fact that the government is obligated to respond as the fulfillment of the logical process implied by the Accountability Clause. The last 10 words of the First Amendment, which instructs the people of their right to petition and thus their right to be answered. Petitions for redress filed with the courts as by individuals or small groups are repeatedly dismissed for lack of standing. Before the court will hear a constitutional challenge of a violation by the government, they require each and every individual petitioner to prove the court that he has the right to stand before the court to argue his case against the government. To prove his standing, the courts require proof that the petitioner's injury resulting from the government's violation of the Constitution is different in kind and degree, more concrete and particularized than the harm suffered by every other person in the country. Since this is not possible, the court's definition of standing means that all unwelcomed constitutional challenges from the people will be dismissed. This position prevents the very foundation upon which the Declaration of Independence and Constitution are built, that each and every provision of the Constitution is guaranteed to each and every person of an individual unalienable right. In a system based on the letter and spirit of our founding documents, every violation of the Constitution does in fact injure or harm the individual and should thereby give him or her the right to stand in court to seek relief. The top of page 19. Under these facts and circumstances, it is well settled in American jurisprudence that silence is an admission. The government, by its silence, has admitted to its violations of the Constitution. Therefore, we the people now find 3 branches of government to be in violation of the Accountability Clause of the First Amendment of the Constitution to the public officials, to be guilty of dereliction of duty in violation of their oath of office, and their actions as listed in the aforementioned petitions for redress to be outside the boundaries drawn around their power and therefore unconstitutional. B. Remedial instructions. Number 1 to Congress. Because the federal judiciary dismisses for lack of standing or lack of jurisdiction these petitions by citizens who seek to remedy violations of the Constitution by public officials, the Congress of the United States shall adopt legislation to amend the federal rules of civil procedure and the federal rules of criminal procedure. 1. Affirming the jurisdiction of all federal courts to hear challenges to the constitutionality of any action by any state or federal public official, elected or appointed, or agency or department. And 2. To prohibit any and all federal courts from denying standing to any individual to challenge the constitutionality of any action by any state or federal public officials, elected or appointed. And 3. To assure that the state or federal judge who violated this rule related to paragraph 1 or 2 above shall be deemed to have violated his or her oath of office, shall be removed from office in accordance with existing rules and disqualified from holding public office thereafter. And 4. Define the meaning of the word proper within the context of the first paragraph above as follows. The term petition is not defined in the Constitution. To be sure, a communication to be protected as a petition to the government for redress of grievances would have to embody certain components to ensure that the government was a petition and not a pretended petition. Not all communications nor any nor just any document can be regarded as a constitutionally protected petition for redress of grievances. Petitions for redress that qualify for protection by the First Amendment include petitions to remedy violations of the Constitution which, bullet, are serious and documented, not frivolous. Bullet, contain no falsehoods. Bullet, are not absent probable cause. Bullet, have the equality of a dispute. Bullet, come from a person outside of the formal political culture. Bullet, contain both a direction and a demand for relief. Bullet, have been punctilious, meaning it follows formatting conventions. Bullet, address public collective grievances. Bullet, involve constitutional principles. Bullet, have been signed only by or primarily by citizens. Bullet, have been dignified, meaning authenticated. Bullet, have widespread participation in consequences. Bullet, are instruments of deliberation, not agitation. Bullet, prove new information. Bullet, do not advocate violence or crime. Page 20. Remedial instructions number 2 to Congress. Because public officials in the legislative and executive branches refuse to respond to proper petitions for redress of grievances, the Congress of the United States shall adopt a concurrent resolution. 1. Affirming the fact that every public official, state or federal, elected or appointed, is obligated to respond to proper petitions for redress of grievances where the term proper petition is defined in instruction B number 4 above. Number 2. Affirming the fact that every public official, state or federal, elected or appointed, should respond to all other petitions for redress of grievances. D. Remedial instructions to the Supreme Court. 1. Affirm the jurisdiction of all state and federal courts to hear challenges to the constitutionality of any action by any state or federal public official, election or appointed or agency or department. Number 2. Prohibit any and all federal and state courts from denying standing to any individual to challenge the constitutionality of any action by any state or federal public officials, elected or appointed, or agency or department, and that. Number 3. Remove any judge from office who violates the above for violating his or her oath of office and disqualifying him or her from holding public office thereafter, all in accordance with existing rules. E. Remedial instruction to the President. The President shall affirm the fact that every public official, state or federal, elected or appointed, is obligated to respond to proper petitions for redress of grievances. F. Remedial instructions to each of the several states. Each of the several states' legislatures shall adopt legislation as necessary to recall from office any elected or appointed public official for failure to respond to any proper petition for redress of grievances. The state legislature shall refuse to accept any and all federal funds until all 3 branches of the federal government are in compliance with the instructions in B through E above. I'm going to pause at page 21 and pick up later. All right, page 21 of 63. 2. The state legislature shall adopt legislation providing for the institution of a citizens' grand jury for the purpose of hearing complaints and issuing indictments against any public official who may be in violation of his or her oath of office and or accountability clause of the First Amendment. 3. The state legislature shall adopt legislation removing impediments to and restoring writs of quo warranto and to obtain hearings on the merits. G. Recommended civic actions by the people. 1. Instruct state legislatures and members of Congress to adopt the aforementioned. 2. Form coalitions or groups to lobby state legislatures and members of Congress to obtain the adoption of the aforementioned. 3. Instruct state officials to remove all oath violators from their positions of authority. And 4. Sign these articles of freedom to give the aforementioned the moral authority it requires. Article 4. Malicious firearms in the Second Amendment. A. Remedial instructions to Congress. Whereas the Second Amendment to the Constitution mandates that in order to provide for the security of a free state, the right of the people to keep and bear arms shall not be infringed, and whereas a multitude of federal statutes constitute de facto infringement now, therefore, we, the delegates of Continental Congress 2009, as free people of America, do hereby instruct the Congress of the United States as follows. 1. Repeal all federal statutes regulating the ownership, use, and transfer of firearms and ammunition. 2. Repeal any federal statutes in which provide for the taxation or registration of firearms and ammunition. Footnote 4 on page 21. Learn more about the subject matter of this article. Read the petition for redress of grievances regarding the government's infringement upon the right of the people to keep and bear arms. See related Continental Congress 2009 video presentation, Jews for the Preservation of Firearm Ownership. 2A, Good for You and the USA film, Ralph Connor, local Legislation Manager, Heartland Institute, the Second Amendment, and No Guns for Negroes is a film to watch. Okay. 22. 3. Abolish the Department of Homeland Security and thereby return the responsibility for domestic security to the militias of the several states. The term militia, inherently separate from the state National Guard, means constitutional defense force comprising of all citizenry capable of bearing arms and under the proper authority and defense of themselves and each of the several of states. 4. Make statutes providing for organizing, arming, and disciplining the militia, and for governing such part of them as may be called to serve the United States, and reserve the states all other powers relating to the militia. 5. Encourage and support and cease and desist from infringing upon the duty of the people to revitalize the well-regulated militia of each of the several states. B. Remedial instructions to each of the several states. 1. Repeal all state statutes regulating the ownership, use, and transfer of firearms and ammunition. 2. Repeal any state statutes which provide for the registration of firearms and ammunition. 3. By statute, establish an advisory commission on revitalization of the militia of their state and the exercise of their powers over the militia as reserved to the several states by the Second and 10th Amendments, as well as other provisions of the Constitution for the United States. The sole purpose of the said advisory commission shall be to study and recommend A. The means including all necessary state legislation and where appropriate legislation authorities direct and independent action by units of local government by which the state can revitalize her militia so as to provide her for her particular requirements of homeland security in keeping with the strict constitutional principles, and B. Such legislation as may be necessary and proper for Congress to enact in order to fully effectuate the state's program of revitalizing her militia in the context of a national program of revitalizing all of the militia of each of the several states to some uniform standard of organization, arms, and discipline. 4. The advisory commission shall be composed of the following persons. Here shall be listed the purposed members of the commission. 5. The advisory commission shall submit a preliminary report to the legislature within 90 days of the enactment of the said statute. This report shall contain inter alia a detailed study with specific recommendations as to how the militia can and should be revitalized, with particular emphasis on those areas of Homeland Security which at the time are within the jurisdiction of the General Government Department of Homeland Security, but the responsibility and authority for the provisions of which the advisory commission believes can effectively be exercised when the state or the militia thereof. Within 30 days of its receipt of that report, the legislature shall return the report to the commission with such directives as it may see fit for alterations, corrections, amendments, additions, deletions, and further studies and recommendations on the basis of the legislature's review within 30 days thereafter. The advisory commission shall submit to the legislature a final report including complete and specific drafts of all state legislation and recommendations for any congressional legislation necessary for revitalization of the militia of the state. 6. Upon receipt of the advisory commission's final report, the legislature shall, without delay, and in any event no more than 30 days later, adopt such report with such amendments as the legislature shall deem proper, and then enact such legislation based on such amended report as will most effectively and expeditiously revitalize the militia. Furthermore, the legislature by resolution shall urge the congressional delegation of said state to introduce support legislation in Congress and adopts the recommendations presented in the advisory commission's final report as amended. The term militia, inherently separate from the state National Guard, means constitutional defense force, comprising all citizenry capable of bearing arms and under proper authority in defense of themselves and the states. C. Recommended civic actions by the people. Whereas the Second Amendment mandates the right to keep and bear arms shall not be infringed, and whereas natural law affirms the right to defense of one's life and property, and whereas the citizens are reminded that the U.S. Constitution is the supreme law of the land and the state laws repugnant to the Second Amendment are null and void, including but not limited to illegal and unconstitutional restrictions on open and concealed carry. Therefore, we, the Continental Congress 2009, declare that a proper method to counter federal usurpation of said rights to encourage the people, each of the several states, to study, exercise their right to keep and bear arms, and to engage the following civic actions. 1. Meet with your county sheriff and ask for assistance and guidance in establishing a constitutional militia. The term militia, inherently separate from the state National Guard, means constitutional defense force comprising of citizenry capable of bearing arms and under proper authority in defense of themselves and the states. 2. Converse, build coalitions, and develop networks of communication with like-minded organizations concerning the importance of constitutional militias, preparedness, and the protection of our right to keep and bear arms. 3. Lobby state legislatures to introduce and or pass a version of what is commonly referred to as the Firearms Freedom Act. 4. Utilize existing Second Amendment scorecards on each of their representatives. Article 5. Privacy and Fourth Amendment. From November 11th to the 22nd of 2009, the Continental Congress convened pursuant to the People's Forum petition of redress of grievances related to the violations of the people's rights of privacy guaranteed to them under the 4th, 5th, 9th Amendments. After deliberation and discussion of the abuses of the rights to privacy, this body provides: A. Remedial instructions to the federal government. 1. Repeal the so-called Patriot Act and its progeny. 2. Repeal the other law that is repugnant to the 4th, 5th, and 9th Amendments. 3. Stop the collection, storing, and dissemination of private information of non-criminal nature belonging to the people. We, the free people of this nation, are not the enemy. 4. Furthermore, we demand that the retraction of any intelligence reports maintained by the Department of Homeland Security not properly cited and sourced, as well as any intelligence report known to contain plagiarized information. 5. Repeal of National Animal Identification System, which requires the RFID of all livestock animals and mapping the premise of the same. 6. Cease the implementation of acts such as Real ID of Act of 2005, the Pass Act of 2009, and to make no future attempts at implementing National ID card or authorizing any funding associated with said act. 7. Do not collect, process, store, or disseminate information of a non-criminal nature. 8. Repeal all laws that collect fingerprints, blood, or DNA upon birth. B. Remedial instructions to the several states. 1. Retract any Fusion Center intelligence report not properly cited and sourced, as well as any intelligence report known to contain plagiarized information. 2. Reject the so-called Patriot Act and its progeny. Footnote 5 at the bottom of page 24. Learn more about the subject matter of this article. Read the Fourth Amendment. Read the petition for redress of grievances regarding the war on terrorism and the USA Patriot Act. See the related Continental Congress 2009 video presentation by Gary Kaw, first delegate from Indiana, introducing shadow government. A film by Cloud 10 Pictures. Catherine Albright, consumer privacy expert, media commentator, and author about privacy issues. 25. 3. Prohibit legislation that allows the installation of red light cameras and other devices used to surreptitiously gather information on American citizens. Repeal any such existing laws. 4. Repeal any legislation that requires government permission to travel, i.e. the requirement to obtain a driver's license to travel, the requirement to register one's vehicle, and or the requirement to purchase motor vehicle insurance unless the vehicle is being used for commercial purposes. 5. All state governments shall cease and desist in prosecuting those men and women who are using the public right-of-way for personal, non-commercial transportation. 6. The language for commercial purposes only shall be added to the definitions of the terms transportation and motor vehicle, in all state laws clearly removing the restrictions imposed on travel for personal, private purposes. 7. Repeal of all state laws that collect fingerprints, blood, DNA, or any other biometric data for minor traffic violations, infractions, or for any other instance where said data is not necessary for investigation. 8. Destroy all biometric data, whether digital or tangible, that have been collected for use with a driver's license or for any other purpose not related to a felony investigation. C. Recommended civic actions by the people. The delegates of the Continental Congress of 2009 wholeheartedly support and encourage the free people of each state to engage in the following. 1. Visit www.cc2009.us and click on the privacy reference list and study all information provided in that list and act in their best interest according to the information provided. 2. Inform themselves about the police and surveillance state that is being created in America in direct violation of the 4th, 5th, 9th, and 10th Amendments. 3. Submit open records requests to the appropriate agencies requesting the items listed below. Consider coordinating these efforts with other activists. A. Copies of all memorandums of understanding MOUs between participating Fusion Center agencies and other party, agency, organizations, institution, governmental body, or individual that relates to Fusion Center information data sharing. B. Copies of Fusion Center privacy policy. C. Copies of all strategic reports produced by or received by said Fusion Centers, including the distribution list citations for each produced strategic report to include identification of the authoring agency of any received strategic reports. C. 4. Expose the findings of said open records requests through online social media, existing liberty media, liberty-minded organizations, and other means of public dissemination. 5. Approach fellow citizens and groups to build an issue-based coalition in order to lobby local and state government to ensure that A. Unless directly involved in a crime, no private sector entities will be involved in the operation of Fusion Centers. B. Only data and intelligence gathering concerning federal crimes may be made available to any federal agency. C. Fusion Centers are not to be used to conduct surveillance on an entire group based on the presence of one suspicious individual. D. Ensure the Creation of a privacy committee to oversee the privacy policy of your local fusion center and ensure compliance. E. Ensure compliance with CFR 28 Part 23. 6. Lobby your state legislature to nullify the Patriot Act. 7. Implement a community response hotline. The people are encouraged to develop alternative means of communication, i.e. ham radio, shortwave, or any other means of electronic communication. B. Be aware. 8. Be aware that no citizen is required to release their Social Security number and should not release it if there is an alternative method. 9. Conduct business only with companies that do not require a Social Security number. 10. Use non-traceable forms of currency, i.e. prepaid credit cards and non-traceable technology, prepaid cellular phones. 11. Use open source software solutions, encrypt their hardware. 11. Use open source software solutions, encrypt their computer hard drives, and use proxy servers when connected to the internet for computer security and privacy reasons. 12. Understand that everyone, including the government, may record photos and video on public property. 13. Buy licensing software agreements and be aware of the privacy ramifications of signing up for such services. 14. Promote local and state legislation that forces local and state governments to further scrutinize the process of accepting grants or other funding concerning surveillance and militarization and federalization of local police departments from federal agencies such as the Department of Homeland Security and the Department of Justice. 15. Lobby for local resolution banning red light cameras or other surveillance equipment in public areas. 16. Furthermore, without delay, the public is advised to contact their state and local representatives to open up dialogue to assure they repeal and propose no further legislation that violates the privacy clauses of the Constitution. Americans also contact their local sheriff and demand they uphold their sworn oath or affirmation to protect and defend the privacy clauses of the Constitution. Article 6. Private property on the 4th, 5th, 9th, 10th, and 14th Amendments. Either you have the right to own your property or you are a property. Wayne Hage, Rancher. A. Background and statement of the facts. The founding documents of the United States clearly acknowledge that the powers of the government are derived only from the consent of the government. Under the American system, individuals decide and direct the terms of their lives, that each person is independent, that justice must be dispensed equally, and that each person has a natural right to his or her life, liberty, and property. The United States is the only nation on earth specifically based on the premise of the right of individuals to own and control private property. It is the essential ingredient for freedom and in the ability to build personal wealth. Private property ownership is the main factor in creating our national prosperity, and it is the root of our individual freedom. Ownership of private property is essential to guaranteeing individual liberty. Without private property, no other rights are possible. There can be no freedom of speech, no freedom of mobility, or no ability to be secure in our persons without the ability to own and control private property. For half a century, unrestrained local and state governments have taken private property not for public uses such as bridges or public buildings as permitted by the Constitution, but for private businesses in the name of economic development. Through the arbitrary use of the eminent domain perpetrated by partnerships between government and private developers, public-private partnerships in the name of undefined common good for the community. Private homes and businesses are being bulldozed, replaced by newer businesses and homes owned not by the public but by private, politically connected individuals and corporations. Internationally, there are outside forces threatening to establish an absolute tyranny over private ownership of the land through the declaration of that all property is part of the global commons, which it declares cannot be owned or controlled by an individual. To that end, a horde of private organizations armed with international treaties, soft law policies, and arbitrary directives have fanned out across the nation, transforming the American system of government, assuring private land is locked away or controlled to the point of rendering it worthless to the owners. Footnote 6 at the bottom of page 27. Learn more about the subject matter of this article. Read 5th Amendment. Read the petition to the federal court regarding the taking of the Kilos private land of private purposes and the decision by the Supreme Court. See the related Continental Congress 2009 video presentations. Tom DeWeese, President, American Policy Center, introduces Michael Shaw, Director, Freedom Advocates, Property Rights Litigation, Dr. Michael S. Kaufman, Executive Director, Sovereignty International, The Decline of Property Rights and Freedom in America. Page 28. These actions subvert the principles of the Declaration of Independence and destroy the governing authority of the United States Constitution. Together we can reverse this trend toward collectivism and uphold the principles of property enshrined in the Constitution, which should forever reign supreme. Constitutional provisions. B. 1. Our Constitution for the United States is the supreme law of the land and has supremacy over decisions of legislature. Article 6, Clause 1 through 3. There can be no rulemaking or legislation which will abrogate the rights secured by our Constitution. Miranda versus Arizona, 384 U.S. 436, 491, 1966. No right granted or secured by the Constitution of the United States can be impaired or destroyed by a state enactment, whatever may be the source from which the power to pass such enactment may have been derived. The nullity of any act inconsistent with the Constitution is produced by the declaration that the Constitution is the supreme law. Connolly versus Union Sewer Pipe Company, 184 U.S. 540, 558, 1902. Number 2. Our people of the United States are guaranteed the unalienable right to life, liberty, and the pursuit of happiness. I don't know if it's unalienable or unalienable, but anyway. I've heard people pronounce it both ways. The three great rights are bound together as to be essentially one right. To give a man his life but deny him his liberty is to take from him all which makes life worth living. To give him his liberty but take from him the property which is the fruit and badge of his liberty is to still leave him a slave. George Sutherland, Associate Justice of the United States Supreme Court, 1921. Number 3. The rights of the people to their property shall not be violated without probable cause, without due process, and without just compensation. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and or the persons or things to be seized. Constitution, 4th Amendment. No person shall be deprived of life, liberty, or property without due process of law, nor shall property be taken for public without just compensation. Constitution, 5th Amendment. 4. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Constitution, 9th Amendment. 5. The power not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Constitution, 10th Amendment. C. Energy independence. The Creator has supplied the earth with an abundance of energy sources. Abundant energy is the foundation for all technological advancement. High and improved quality of life is totally dependent on an abundance of energy. The Constitution does not grant the federal government the power to regulate, control, or establish a national policy for the generation and distribution of energy. Within the United States, there is nearly an unlimited supply of coal, oil, natural gas, and hydroelectric energy sources. Carbon dioxide generated from these sources is an environmental pollutant, but is not an environmental pollutant, but is in fact an essential and vital element of life, enhancing life rather than negatively impacting it. The extraction, transportation, and processing of energy resources, our property, is fully our constitutional right. So too, the production of nuclear energy. Some convincingly argue that nuclear energy is the safest, cleanest, and least expensive source of energy, and that nuclear waste can be disposed of at the reactor site. D. The Wildlands Project, conservation of biological energy. The United States has assumed control of lands within several of the western states for far but beyond the authority to granted to it by the Constitution of the United States. CMAP. When the federal government assumes control, it does so by calling those seized lands such names as the Wildlands Project, heritage areas, land management, wolf and bear reintroduction, and rails to trails, conservation easements, open space, and many more. Each of these programs is designed to make it more difficult and expensive to live on the land. The federal government has established and expanded parks, preserves, recreation, and wilderness areas with no regard for the economic impact, loss of livelihood, and custom and culture of residents of the area. These types of projects are established often without the direct consent of the legislature or the state or the people or of the community, and without concern for the impact on the communities. For example, the economy of small communities and of the Hells Canyon National Recreation Area is being heavily impacted. The residents of many similarly situated communities are suffering greatly when the federal government takes several million acres of land for use in these wilderness projects. In these projects, among other things, the watershed areas will no longer be under the guidance and care of the citizens of those communities. Remedial instructions to Congress. We the people find that 3 branches of government have violated the above provisions of the Constitution and therefore provide the following instructions. 1. Reintroduce and pass the Property Rights Protection Act S. 1313. This legislation passed in the House of Representatives in 2005 was introduced to overturn the Supreme Court's Kelo decision. The legislation specifically called for cutting off of federal funds to any community that uses eminent domain for community development of private property. It was blocked in committee in the Senate. Passing this legislation is vital to correcting the destruction to American property rights caused by the Kelo decision. 2. Repeal this legislation related to terms such as sustainable development, social justice, global community, or otherwise focused on land use, education, or population control/reduction. Strengthen the Fifth Amendment by law, not a constitutional amendment, by requiring government at all levels to pay just compensation for regulatory takings. 4. Repeal and provide no funds to any agency working toward a North American Union, regional, or global governments of any kind. Repeal all laws restricting the people's right to private property, its acquisition, its use, and its disposal. 6. Defund and repeal all Environmental Protection Agency legislation related to the United Nations movement to collectivize all property. 7. Reject or repeal all legislation related to public/private partnerships that relate to controlling population or setting new public policy aimed at making communal the property of the people. 8. Independently evaluate any determinations by the United Nations or any non-governmental international organization that are supportive of their promotion of a top-down governance of society. 10. Refuse to enter into the Copenhagen Treaty. 11. Refuse to provide any funds to non-governmental organizations, NGOs. 12. Discontinue any association or funding any activities related to the Security and Prosperity Partnership, North American Leaders Summit. 13. Repeal all the laws that take property from sovereign individuals merely accused or suspected of a crime. 14. Rewrite environmental laws to protect private property rights limited only by historic harm and nuisance provisions of common law and mandate that federal lands meet their own standards. Repeal all laws, regulations, and funding related to the national heritage areas. 16. Prevent eminent domain from being exercised to convert private property from one owner to another private owner for public advantage. Eminent domain is only to be used to convert private property to public use for at least 20 years. We'll start again on page 31. Okay, continuing with page 31. Repeal all laws granting the Army Corps of Engineers control over land and water rights of private property owners. 18. Repeal all laws, regulations, and or directives of any kind that regulate, control, or establish a national policy for the generation and distribution of energy. And 19. Let the free market determine how energy is generated and distributed. F. Remedial instructions to each of the several states. Eliminate all taxes on private property such as land, buildings, tenements, automobiles, chattels, estates, real estate, private real property, personal property, or property tax assessments. 2. The legislature shall develop laws and regulations required to establish a state policy for the generation or distribution of energy that is based upon free market principles and operates pursuant to the rights of the states under the 10th Amendment. 3. Leave the regulation, generation, and distribution of energy to the free market. 4. Pass a resolution declaring the federal government has no power to regulate, control, or establish a policy for the generation or distribution of energy within the state. 5. Pass laws defining private property and blocking the use of eminent domain for community development of private property. G. Recommended civic actions by the people. 1. Encourage self-education of property rights protected by the Constitution. 2. Get involved concerning the benefits of free market solutions to generation and distribution of all sources of energy. 3. Establish a petition drive throughout the state indicating the energy generation and distribution must be free from all government control. 4. Develop initiatives to place on the ballot that indicate your individual right to a free market in energy generation and distribution. 5. Contact your state senator, representative, and the governor and demand that they pass legislation that ends the federal government regulation of energy generation and distribution within the state. 6. Educate yourself about the truth behind the climate change and the reality that global warming is not caused by man through carbon emissions. 7. Go to city council meetings to listen and participate in discussions. 8. Inquire through your council members during a meeting by setting up a personal meeting to determine the role of the International Council on Local Environmental Initiatives in driving policy at the local level. 9. Build coalitions of like-minded groups in order to build opposition to the implementation of Agenda 21 sustainable development at the local level. 10. Demand that your local government respect your right to a Republican form of government as enumerated in the United States Constitution and the various state constitutions by ceasing the use of the consensus process and predetermined outcomes and comprehensive planning in order to dictate policy and implement anything that interferes with private property ownership. 11. Reject the local reception of federal non-governmental organizations or foundations, grants, and/or funding to the extent that they further the implementation of Agenda 21. 12. Actively oppose local government participation with federal programs. Number 10. Demand your local government respect your right to a Republican form of government as enumerated in the United States Constitution and the various state constitutions by ceasing the use of the consensus process and predetermined outcomes and comprehensive planning in order to dictate policy and implement anything that interferes with private property ownership. 11. Reject the local reception of federal non-governmental organizations or foundations, grants, or funding to the extent that they further the implementation of Agenda 21. 12. Actively oppose local government participation with the federal programs or agencies that seek to further the implementation of Agenda 21 sustainable development. 13. Actively oppose the creation of public-private partnerships between local government and private industry. 14. Educate yourself concerning methods to combat the consensus process which seeks to manipulate the public into predetermined outcomes. 15. Address, petition, and support all state, reassert, and reaffirm the 10th Amendment by passing legislation exerting the 10th Amendment powers for land use management. 16. Encourage, petition, and support county officials to notify all government agencies, state and federal, to comply with the 10th Amendment and other constitutional provisions. Counsel and lobby Congress to return ownership of public lands, parks, preserves, recreation areas, and areas designated to the states in whose boundaries the land lies. Article 7, Juries and 7th Amendment, a background and statement of facts. Footnote number 7 at the bottom of page 32. Learn more about the subject matter of the article. Read 7th Amendment in the related Congressional Congress 2009 video presentations. Martin J. Red Beckman, founder, Fully Informed Jury Association, constitutional activist and author. Law System, Jury Nullification, 7th Amendment, and Fully Informed Jurors. Page 33. The delegates representing 48 of the several states and Continental Congress assembled, being fully apprised in the premises, find that number 1, the American people are the American sovereign. 2, as sovereign, the American people have the last say on the law. 3, American citizens are called to sit on both grand and petite juries. 4, in their capacity as jurors, the American people have the power and the duty to judge both the law and the facts. Remedial instructions to Congress. Number 1, amend the Federal Rules of Civil Procedure to require judges to apprise all plaintiffs and defendants of their right under the 7th Amendment common law jury. And 2, amend the Federal Rules of Criminal Procedure to require judges to apprise defendants of their right under the 7th Amendment to a common law jury. And 3, amend the Federal Rules of Civil and Criminal Procedure to require all judges in cases where the United States is party to the case to apprise all juries of the judge's conflict of interest. And 4, amend the Federal Rules and Criminal Procedure to provide for trials authorized only by indictments of presentments by independent randomly impaneled and citizens common law grand juries, accessible to any individual having a complaint and power to authorize any citizen of their choice to prosecute a case. C, remedial instructions to each of the several states. 1, amend the rules governing civil and criminal cases to require judges to apprise plaintiffs and defendants of their right under the 7th Amendment and a common law jury. 2, amend the rules governing civil and criminal cases to require all judges in cases where the state is a party to the case apprise all jurors of the judge's conflict of interest. D, recommended civic actions by the people. 1, when appointed to a jury, throw off the restraints of judicial tyranny by refusing to capitulate to any judicial instruction to judge only the facts. And 2, when appointed to a jury, demand to have all issues of law argued in the presence of the jury and have the last say by judging the law. 3, educate your family, friends, and community to learn about the Fully Informed Jury Association and the power of judging the law as well as the accused. Article 8, Income Tax and 16th Amendment, Background and Statement of Facts. Whereas from November 11th to the 22nd of 2009, the Continental Congress convened pursuant to the people's formal petition for redress of grievance related to the federal income tax and the long train of abuses and usurpations relating to the federal income tax. After a comprehensive, exhaustive, and lengthy deliberation of the current and historical facts and law, the delegates find: 1. That our servant federal government has failed to directly respond to the people's petition and in fact has indirectly responded to threats, intimidation, and repeated harm. 2. That the 16th Amendment of the United States Constitution definitively and conclusively failed to be properly and legally ratified, thus rendering it a void ab initio. 3. That the income tax currently applied and definitively and conclusively an unconstitutional direct unapportioned tax on labor, the most sacred and unviable property of the citizens of the United States. See Butcher Union versus Crescent City Company, 111 U.S. 746 757. 4. That the institutionalized withholding from the paychecks and earning of the citizens is definitively and conclusively unconstitutional. B. Remedial instructions to Congress. Now, therefore, without delay, the Congress of the United States is hereby instructed to: 1. Immediately conduct a review of the facts surrounding its ratification and recognize that the 16th Amendment is void. 2. Immediately cease the enforcement and collection of the direct unapportioned income tax on the labor of the citizens of the United States. 8. Learn more about the subject matter of this article. Read tax clauses of the Constitution. Read the petition for redress of grievances related to the federal income tax. Read the petition for writ of certiorari regarding the 16th Amendment. See the related Continental Congress 2009 video presentations. Joseph Bannister, former Special Agent, IRS and Criminal Investigation Division, personal experiences regarding his petition for redress regarding the unconstitutional operational and enforcement of the Internal Revenue laws. Jeffrey Dickstein, attorney. Here are the facts regarding the petition related to the non-ratification of the 16th Amendment and the direct unapportioned tax on labor. Additional resources for consideration: petition for redress of grievances related to income tax, November the 4th, 2002, including a statement of facts and beliefs, 538 income tax questions, we the people, 538 income tax questions, we the people, presented to the Congress and the IRS, which were answered by tax professionals under oath. Page 35. 3. Immediately cease the imposition, enforcement, and collection of withholding earnings from the paychecks of the citizens of the United States. 4. Immediately release and fully restore all citizens wrongfully imprisoned as a result of the unconstitutional application of the income tax. C. Remedial instruction to each of the several states. Therefore, each of the several states shall: 1. Repeal any and all state income tax laws to the extent that they are rooted in or based upon the unconstitutional operation and enforcement of the federal revenue laws. 2. Preserve, protect, defend, and liberty and property of all citizens against unconstitutional seizures by the federal government pertaining to the unlawful collection of income taxes. 3. Cease the unconstitutional imposition and collection of the state income tax upon the unalienable right of its citizens' labor. To wit, it has been well said, the property which every man has is his own labor, as it is the original foundation of all other property, so it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder his employing this strength and dexterity in what manner he thinks proper, without injury to his neighbor, or is a plain violation of this most sacred property. See Butchers Union Company versus Crescent City Company, 111 U.S. 746 757. Compensation for labor cannot be regarded as profit within the meaning of the law. The word profit, as ordinarily used, means the gain made upon the business or investment, a different thing altogether from mere compensation for labor. See Commercial League Association of America versus the People, X related 90 Illinois 166 173. D. Recommended civic actions by the people. Whereas from 11th of November until 22nd November 2009, the Continental Congress convened pursuant to the people's formal petition of redress of grievances related to the federal income tax and the long train of abuses and usurpations related to the aforementioned tax. Whereas tyranny by means of taxation is one of the most oppressive aspects of government and must be guarded against to protect man's unalienable rights. Whereas all government activity that provides funding for unconstitutional programs is to be considered tyrannical in nature and should be condemned by the people as a whole. Whereas, after a comprehensive, exhaustive, and lengthy deliberation of historical facts and law, Continental Congress 2009 finds: A. That our servant federal government has failed to directly respond to the people's petition and in fact has indirectly responded with threats, intimidation, and repeated harm. B. That the 16th Amendment to the United States Constitution definitively and conclusively failed to be properly and legally ratified, thus rendering it void. That the income tax as currently applied is definitively and conclusively an unconstitutional direct unapportioned tax on labor, the most sacred and inviolable property of the citizens of the United States. D. That the institutionalized withholding from the paychecks and earnings of the citizens is definitively and conclusively unconstitutional. Therefore, we, the delegates of Continental Congress, recommend the people: 1. Study and understand the research done by Bill Benson in his book, The Law That Never Was, And once they have a firm understanding of the argument, they are encouraged to educate their family, friends, and fellow Americans about the truth behind the 16th Amendment. 2. Contact their local county government, including the sheriff, and demand cooperation and enforcement of state law, federal laws prohibiting the illegal filling out notices of federal law tax liens and filling in the federal tax lien and levy without proper federal court orders attached. It is the duty of the sheriff to protect the citizens of the county from rogue federal agents acting under a color of law. 3. Put their banks and employers on notice that federal income tax levy should not be honored without federal court order attached and without an affidavit from the sheriff that the levy is legal and proper. 4. Prepare to replace any sheriff or county or state government officials at the next election or sooner through impeachment or recall who refuse to cooperate and honor their oath of office to protect and defend the federal and state constitution and the people. 5. Be prepared to withhold their income tax from the government once the above steps of self-defense are in place. 6. Furthermore, without delay, the public is advised to contact their county sheriff, state, and federal representative and senators demanding the unconstitutional taxation withholding of earnings be stopped immediately. Article 9, Foreign Policy and General Welfare Clause of the Preamble to the Constitution. Background and statements of the facts. The general welfare is mentioned twice in the Constitution of the United States. First, in the preamble, where embedded in with other reasons to establish a constitution, it is started to promote the general welfare. Article 1, Section 8 then states the Congress shall have the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. This declarative sentence is followed by a list of powers that restrict what Congress may do in this regard. As James Madison states in the Federalist 41 reference, the General Welfare Clause, nothing is more natural or common than to use a general phrase and then to explain or qualify it by a recital of particulars. Madison further writes that it would be an absurdity if the list of particulars was interpreted as anything but restrictive on the general statement. Therefore, notwithstanding the interpretations of the past century, the Congress of the United States has misinterpreted the General Welfare Clause in order to expand its powers and to impose the tyranny of unjust taxes upon the people. The preamble of the Constitution reveals that one of the reasons for its creation is to promote the general welfare of the people. A foreign policy which seeks to meddle in the internal affairs of foreign countries, including the act choosing sides, is clearly detrimental to this cause. The 9/11 report documents that this policy of meddling has caused foreign nationals to turn their hostilities toward Americans. These hostilities have given rise to domestic policies such as the so-called War on Terror, which have resulted in the enactment of statutes such as USA Patriot Act that are inconsistent with so-called privacy clause of the Fourth Amendment. There can be no doubt that this policy has endangered the security of the American people and has restricted their natural rights. This approach to relations with those beyond our borders clearly does not serve the general welfare and does not serve the national interest. Footnote 9 at the bottom of page 37. Learn more about the subject matter of this article. Read the general welfare clauses. Read the petition for redress of grievances regarding the United States' unconstitutional financial aid to Israel and occupation of various countries in the Middle East. See the related Congressional Conference 2009 video presentation. George Washington, First President David Justice, WTPC State Coordinator, Foreign Policy. Excerpts from George Washington's farewell address. The federal government has been served with a petition for redress of this grievances. However, the government has failed to respond. Such refusal to respond, along with the infringement of natural enumerated rights, freedoms, and liberties, reflects the behavioral characteristic of a police state. The general welfare of the people is the principal goal of the United States Constitution, which implies a foreign policy consistent with the admonition of George Washington in his farewell address regarding the foreign nations to have with them as little political connection as possible. We might look to Switzerland, a landlocked country in Central Europe, which has one of the highest GDP per capita in the world, which has avoided wars since 1815, despite shared borders with Germany, Italy, France. Switzerland has remained aggressively neutral, and her citizens are well armed and well prepared in the defense of their country. B. Remedial instructions to Congress. Follow the Constitution for the United States. 1. Discontinue funding for any foreign aid and or funding that is not necessarily for the defense against invasion of the United States. 2. Treaties that are inconsistent with or that violate the Constitution that have been ratified shall be nullified. Any further treaties that would infringe upon individual rights, liberties, and freedoms or that otherwise repugnant to the Constitution shall not be ratified. 3. Repeal the Patriot Act, the Military Commissions Act, Real ID, and any other statute repugnant to the Fourth Amendment of the Constitution. C. remedial instructions to each of the several states. The state legislature of each of the several states shall pass a resolution in support of the above instructions to the Congress, thus exercise our just powers as guaranteed by the 10th Amendment of the Bill of Rights. D. Recommended civic actions for the people. We call upon the people to 1. Raise their voices with ours and those of each of the several states in support of the above instructions to the U.S. Congress. 2. Educate themselves and encourage their fellow citizens to increase their knowledge and awareness of this topic in order to bring our elected officials back under the control of the Constitution and therefore of the people. 3. Become personal ambassadors of goodwill to citizens of all nations. Page 39. Article 10, Money, and Article 1 of the Constitution. A. Remedial instructions to Congress. 1. The Congress of the United States, in the exercise of its power authorized by Article 1, Section 8, Clause 5 of the Constitution for the United States of America to coin money, regulate the value thereof, and of foreign coin, shall enact a statute. A. Establishing National Advisory Commission on Alternative and Competitive Currency, and B. Calling upon each of the several states to establish their own state advisory commission on alternative and competitive currency. 2. That the sole purpose of the said advisory commission shall be to study and recommend the means by which each state individually and the several states Congress collectively can promote the adoption by both the several states and the United States as rapidly as possible of an economically sound and constitutional alternative and competitive currency, which shall A. Consist exclusively of silver and gold. The units consist of 37.125 grains Troy fine silver and 37.125 grains Troy fine gold, which shall be subject to transfer from one party to another in both an electronic form, measurable in any amount of units, as well as tenths, hundredths, thousandths of a unit. I'm getting a phone call here. Hold on. Okay, let's continue here. Top of page 39. Calling upon each of the several states to establish their own state advisory commission on alternative and competitive currency. Oh, I think I read that. We were down to as well as tenths, hundredths, thousandths of unit, and the form of coins, whether of traditional or non-traditional shapes, of convenient weights consisting of multiples of the units or common fractions thereof, gradually be introduced in the media's exchange in all forms in all the financial transactions of the government of each of the several states and of the United States, so as in a measured manner to minimize and financially supplant the use in such transactions of. Okay, there's a footnote 10 at the bottom of page 39. Learn more about the subject matter of this article. Read the money clause of the Constitution. Read the petition for redress of grievances related to the Federal Reserve System. See the related Continental Congress 2009 video presentation. Tom DeWeese, first delegate from Virginia, reading the submission from Dr. Edwin Vieira, The Power of the Purse, William Bergman, and Alice Morningstar, My Experiences as an Analyst of the Federal Reserve System, and Robert L. Schultz, Chairman. We the People Foundation for the Constitutional Education comments on the petition for redress of grievances related to the Federal Reserve System. Additional resources for the consideration petition to the federal court regarding the unconstitutional bailout of the Mexican peso. There were 4 causes of action in this case by Schultz and other plaintiffs. The 4th was the action by Schultz and other that the attempted $20 billion bailout of the Mexican peso by President Clinton and Treasury Secretary Robert Rubin should be declared unconstitutional, null and void. The case was dismissed by the court for lack of standing. Okay, I'm gonna stop at the page. Let's go to page 40. Federal Reserve notes or bank balances payable in those notes to the maximum degree possible, consistent with the general welfare, and eventually supplant the use of such notes or balances in all private monetary transactions among each of the several states to such degree as the free market determines economically appropriate. The National Advisory Commission shall be composed of the following persons. Here shall be listed the proposed members of the commission. 3. That within 30 days from the effective date of the said statute, the National Advisory Commission shall submit to Congress a report containing complete and specific drafts of all such legislation as may be necessary and the proper for Congress to enact in order to guarantee that the citizens of each state may employ any alternative and competitive currency in all their private economic transactions, free from any form of taxation, reporting, or other regulation by the United States or any agency thereof, or by any state or agency thereof, that increases in cost, hinders, deters, discourages, delays, or renders cumbersome the use of such currency, or the consummation of transactions in which such currency is the medium in payment, in comparison to the same use of consummation of similar transactions involving the Federal Reserve notes or bank balances payable in such notes. That within 30 days of its receipt, the National Advisory Commission's report submitted pursuant to paragraph 2 ante Congress shall enact the legislation as well as will achieve the goals set out in that paragraph. 5, that within 90 days from the effective date of the said statute, the National Advisory Commission shall submit to Congress report containing complete and specific drafts of all such legislation as may be necessary and proper for Congress to enact in order to achieve the goals set out in paragraph 2 ante for the government of the United States. 6, that within 60 days of its receipt of the National Advisory Commission's report pursuant to paragraph 5 ante, Congress shall enact such legislation as will achieve the goals set out in paragraph 2 ante for the government of the United States. B, remedial instructions to each of the several states. 1, that the legislature in the exercise of its reserve power under Article 1, Section 10, Clause 1, and the 10th Amendment, as well as other provisions of the Constitution for the United States, shall adopt currency other than that emitted by Congress for use in all the financial transactions of the state. There shall by statute establish an advisory commission on alternative and competitive currency for the state, the purpose of which shall be to study and recommend the means, including all necessary state legislation and where appropriate legislation that authorizes direct and independent action by units of local government, by which the state can adopt an economically sound and constitutional alternative and competitive currency, consisting exclusively of silver and gold initially for use in all of the financial transactions of the state government, thereby minimizing the use in such transactions. Okay, I'm going to stop at the top of page 41. Page 41. Transactions of Federal Reserve notes or bank balances payable to those notes and eventually to supplant the use of such notes or balances in all private economic transactions within the state to maximum degree possible for the benefit of its citizens. 2. Such legislation as may be necessary and proper for the state to enact in order to guarantee that the citizens of the state may employ such alternative and competitive currency in all their private economic transactions, free from any form of taxation, reporting, or other regulation by the state or agency thereof that increases in cost, hinders, deters, discourages, delays, or renders cumbersome the use of such currency or the consummation of transactions in which such currency is a medium of payment, in comparison to the same use of or consummation of similar transactions involving Federal Reserve note or bank balances payable in such notes. 2. That the Advisory Commission shall be composed of the following persons. Here list the proposed members of the Commission. 3. That the Advisory Commission shall, within 60 days of the effective date of the state said statute, submit to the legislature a report containing complete and specific drafts of all such legislation as may be necessary and proper for the legislature to enact in order to achieve the goals set out in paragraph 1 ante. 4. That the legislature shall, within 60 days from its receipt, the drafts of legislation submitted by the Advisory Commission pursuant to paragraph 3 ante, enact such legislation as will achieve the goals set out in paragraph 1 ante. C. Recommended civic actions by the people. Whereas Article 1, Section 10 of the U.S. Constitution specifies that no ante shall be anything but gold and silver coin tender in payment of debts, and understanding a Federal Reserve as a private banking cartel whose effect has been to reduce the value of the dollar approximately 96% since its inception, Continental Congress 2009, in the interest of economic liberty. 1. Encourage networks of like-minded individuals to increasingly buy hard money coinage to use among their communities with the goal of increasing financial independence. And 2. That the aforementioned individuals, having upon established trade procedures is said hard money, shall be prepared for the replacement of the unconstitutional Federal Reserve upon its failure or abolition. Page 42. Article 11. Public debt and Article 1 of the Constitution. A. Background and statement of the facts. Whereas we, the delegates assembled as Continental Congress 2009, desire to express our deepest concerns relative to the uncontrolled and unconstitutional spending of Congress, and whereas irresponsible spending by Congress without regard to the supreme law of the land is unconscionable, this document presents our concerns over the accelerating accumulation of unconstitutional and uncontrollable public debt. Moreover, we demand the extinguishment of such monstrous mountain of debt which has been created because of government officials' blatant disregard of their oath of office to uphold the Constitution and the principles of our American Republic. Due to their lack of understanding, most Americans are not knowledgeable about the founding principle of our constitutional republic. Congress continues to accumulate this heavy burden without regard to our Constitution. Therefore, listen to the warning voices of our founders on this critical subject. Indeed, we cannot too often include upon you or desires that all extraordinary grants and expensive measures may upon all occasions as much as possible be avoided. The public money of its country is the toil and labor of the people. Reasonable frugality ought to be observed, and we would recommend particularly the strictest care and the utmost firmness to prevent all unconstitutional draughts upon the public treasury. Instructions of Braintree, Massachusetts, to their legislative representative, 1765. As a very important source of strength and security, cherish public credit. Use it as strongly as possible. Avoid likewise the accumulation of debt in time of peace, discharging the debts which unavoidable wars may occasion, not ungenerously throwing upon the posterity the burden which we ourselves ought to bear. George Washington Farewell Address. Persuaded as the Secretary is that the proper funding of the present debt will render to it a national blessing, yet he is so far from acceding to the position in the latitude in footnote number 11 at the bottom of page 42. Learn more about this subject matter of this article. Read Constitution. Read the petition to the federal court regarding the unconstitutional $85 billion bailout of AIG in 2008 and decision. Read the petition of the federal court regarding the unconstitutional $700 billion bailout of U.S. financial industry in 2008 decision. See the related Continental Congress 2009 video presentations. Robert L. Schultz, Chairman, We the People Foundation for Constitutional Education. We the People lawsuits against the $85 billion AIG and $700 billion bailout. And Tom DeWeese, first delegate from Virginia, reading the submission of Dr. Edwin Vieira, declaration that all unconstitutionally incurred public debt of the United States is void and enforcement thereof. Page 43. Which it is sometimes laid down that the public debts are public benefits, a position inviting the prodigality and liable to dangerous abuse, that he adherently wishes to see it incorporated as a fundamental maximum in the system of public credit of the United States, that the creation of debt should always be accompanied with the means of extinguishment, that he regards as a true secret for rendering public credit immortal. Secretary of Treasury Alexander Hamilton, for first report on the public credit, 1790. The issuing of money should be taken from the banks and restored to the people to whom it properly belongs. Our founding fathers have sent us a message of warning over the centuries of continuing the present policy of public debt. Suffice it to say, we need to stop our overly burdensome, frivolous, constitutional and unconstitutional spending. Now, in times of such severe debt, discretionary spending is unacceptable. Therefore, we acknowledge that debt is a merciless master to which we will not submit. Therefore, the Continental Congress 2009 recommends that within 60 days after the general recess of Continental Congress 2009, citizens be selected from the several states thoroughly familiar with all the constitutional principles relevant to validity of public debt of the United States to come together for the purpose of reviewing the validity of the public debt as authorized by law and the purpose of preparing a comprehensive report of their findings. This report is to be completed within 120 days of the selection of the individuals. The citizens shall determine and prepare a report with respect to which of the alleged public debts of the United States are void and are voidable under two principles of law, namely, 1. Under the doctrine of the Supreme Court's decision in Craig v. Missouri, 29 U.S. 4 Peters 410, 1830, all contract agreements or other arrangements in which part of the consideration consists or consisted of the emission of unconstitutional bills of credit through under the auspices of the Federal Reserve Bank, member bank, or depository institution within the Federal Reserve are void ab initio and unenforceable in any court of the United States or any state. 2. Alleged public debts of the public states, however made in whatever form, that have been incurred for the purpose of raising revenue to be expended from the general fund of the Treasury and payment of cost arising under a particular budget of the United States and avoid ab initio and unenforceable in the court of the United States or any state in the same percentage that the unconstitutional programs, activities, expenditures in that budget to bear the total programs, activities, or expenditures therein. Every lender must be presumed to know the constitutional limits of the expenditures of money the general government borrows to the same extent that every official at the government knows those limits. So if a lender extends a loan to the public officials knowing that his loan will be used for unconstitutional purposes or with willful blindness or to a reckless disregard of the unconstitutional of those purposes, he is thereby a participant in fraud against the American people and for the repayment of such a loan. The American people cannot be held liable. Remedial instructions to Congress. Page 44. Wherefore, we as a body of delegates constituting the Continental Congress 2009 hereby instruct our elected representatives to 1. Cease unconstitutional spending. Cease irresponsible spending. 2. Limit the spending to those items as encountered in Article 1, Section 8, or as otherwise specifically authorized by the Constitution. 3. Order the Federal Reserve to reacquire all of its assets from all foreign banks, including the IMF. 4. Order the Federal Reserve to transfer all assets to the Treasury of the United States. 5. Hold the majority of its reserves in gold, silver, or other metal classified as precious in a secure location within the borders of the contiguous 48 United States. 6. Repeal and rescind legal tender laws and not interfere in any way with any private medium of exchange, private script, or currency that may emerge. 7. Repudiate any and all public debt that has been unconstitutionally acquired. 8. Preclude the confiscation of any private ownership of gold or silver or any other precious metal analogous to the confiscation of gold and silver by President Roosevelt in 1933. 9. Preclude the confiscation or prohibition of any private medium of exchange, private script, or currency that may emerge. Preclude the adoption of any laws, orders, or directives prohibiting the use of any private medium of exchange, private script, or currency that may emerge. 11. Unmask the deceptive practice of placing some authorizations, appropriations in a hidden off-record account and direct specific accountability for all expenditure. 12. Tighter auditing of expenditure to preclude the unaccountable loss of untold billions of dollars. 13. Implement the immediate investigation of the loss of funds and to begin the immediate prosecution of all persons suspected in the involvement or association with the loss. 14. Repeal the Federal Reserve Act and all laws pertaining thereto. And 15. Do not enforce federal income tax withholding laws, rather adopt legislation requiring that individuals provide any taxes due directly to the federal government. Okay. Further, it is the consensus of the delegates to Continental Congress 2009 that members of the Congress have the inherent and moral responsibility to abide by its tenets, to attest to their having signed the oath of affirmation of office as required by the U.S. Constitution, Article 2, Section 1, and Article 6. Page 45. Oaths in this country are as yet universally considered a sacred obligation. That which you have taken so solemnly repeated on the venerable spot is an ample pledge of your sincerity and devotion to your country and its government. John Adams. In 1969, the Congress approved national debt was $286 billion. As a result of the congressional irresponsibility, the debt was grown to over $12 trillion, which means that every child born in the nation is instantly shackled with debt of more than $39,000. You're going to pick something up?
4 o'clock almost.
Oh, are you going to go with me?
It's almost time to leave.
Okay. I'm going to stop at the top of page 45. Okay, starting with page 45. Oaths in this country are as yet universally considered a sacred obligation, that which have taken so solemnly repeated on the venerable spot in ample pledge to your sincerity and devotion to your country and its government. John Adams. In 1969, the Congress approved national debt was $286 billion. As a result of congressional irresponsibility, the debt has grown to over $12 trillion, which means that every child born in the nation is instantly shackled with a debt of more than $39,000. This means that the most families have an annual debt that far exceeds their income. See chart below. Moreover, various authorities have suggested that the true public debt is over $106 trillion. This larger amount represents the inclusion of unfunded liabilities such as Social Security, prescription drugs, Medicare, off-records appropriations, and unconstitutional spending. Then there is a chart that goes from 1969 to 2020. The personal debt, the debt in 1969 was $286 billion. The population was 179 million. The personal debt was 1,900. In 2020, it's expected to be 24 trillion. Population 342 million, with a personal debt of $70,000 each. Okay. C. Remedial instructions to each of the several states. It is the belief of the Continental Congress 2009 that our states are being directly and indirectly impacted by the public debt created by Congress. The theft of our finances to pay for unconstitutional and irresponsible constitutional spending on the part of Congress impacts the economy of every individual. The uncontrollable spending by Congress effectively steals monies that could otherwise be used by personal growth by the citizens of the various states, thereby creating a welfare, socialist, fascist state where the citizens look to Washington, D.C. for every aspect of their lives. When the states pattern their financial policies after the federal government, the result is an increase in taxes on the citizens, thereby exacerbating the people's burdens. Therefore, we instruct the several states to 1. Reassert the rights expressed in the 10th Amendment to act autonomously. 2. Refuse to accept any Federal Reserve notes. 3. Refuse to give the federal government any funds that could be used for an unconstitutional spending. D. Recommended actions by the people. The delegates of the Continental Congress hereby express our deepest concerns relative to the uncontrolled and unconstitutional spending of Congress and issue the following urgent notice to all American citizens. Our government has plunged us into debt through excessive and senseless spending. Repayment of the portion of this debt that cannot be liquidated by sale or seizure of public property or by other means indicates that it will fall upon us in the form of taxes, including the hidden tax of inflation. In one way or another, the wealth that is taxed is created by the labor of the people. Therefore, we recommend to the people the following to begin the correction of our economy. 1. If your state has engaged in irresponsible spending resulting in large public debt, we recommend the citizens instruct their government to cease those practices. 2. Increase our power to produce by increasing our education level, keep our eyes open for changing dynamics, and look for new opportunities, learn and develop new craft skills, and learn how to create more value for more people. Learn how to create more value for more people. 3. Learn how to be self-reliant rather than government-dependent. Any benefit that the government provides to one individual must be taken from others. 4. Increase your savings by selling fiat currency and buying hard assets. Eliminate all forms of personal debt. 5. Introduce the principle of barter and alternative media of exchange and educate your local community. 6. Businesses are encouraged to begin accepting gold or silver as a viable payment for commodity of service exchanges. 7. Work with local businesses to implement an alternative local bartering system or establish a local primitive medium of exchange. 8. Only vote for candidates for office who are true constitutionalists and who are committed to reducing government spending and borrowing. 9. Encourage elected state officials to return to the gold and silver standard, pass sound, honest money legislation to provide a competing currency to the current existing fiat currency. 10. Share the information contained in the Continental Congress 2009 documents with your state legislatures, county and local officials, and the media. Page 47, Article 12, War Powers and Articles 1 and 2 of the Constitution. A. Background and statement of the facts. Whereas the Constitution for the United States of America clearly grants Congress the exclusive power to declare war, grant letters of marque and reprisal, and mark rules concerning the captures and land on water. Article 1, Section 8, Clause 11. Whereas Congress may not delegate this power under any circumstances unless the Constitution is amended. Article 5. And whereas the Constitution is also declares that the President serves as Commander-in-Chief only when called upon service by Congress during the time of invasion or rebellion. Article 2, Section 2, Clause 1, and whereas only Congress can initiate war and the President merely executes and administers it, and whereas history has proven that war powers are invariably abused when left in the hands of one individual, whereas all war activities should be for the sole purpose of national defense, Article 1, Section 8, Clause 1, and whereas the citizens of several states and the United States of America have been subjected to a series of undeclared national emergencies, beginning with Executive Order Number 1, issued by Abraham Lincoln on April the 15th, 1861, and reactivated by Franklin Delano Roosevelt and Congress in 1933, and whereas these declared states of emergency, many of which continued uninterrupted to this day, have given successive presidents a multitude of autocratic powers, and footnote number 12 at the bottom of page 47. Learn more about this subject matter in the article. Read War Powers Clauses. Read the petition for redress of grievances relating to the application of armed forces of the United States in hostilities with Iraq without a congressional declaration of war. See the related Continental Congress 2009 videos of Dr. Adler, Professor of Political Science, Idaho State University, author, The History, Meaning, Effect, Significance, and Violations of the War Powers Clauses of the Constitution. Additional resources for consideration: petition to the federal court regarding the unconstitutional bombing of Kosovo, dismissed by the court for lack of standing. Page 48. Whereas the Senate Report 93-549 War and Emergency Powers Act 1973-93 Congress First Session states in part, these proclamations give force to 470 provisions of federal law. These hundreds of statutes to delegate the President extraordinary powers ordinarily exercised by Congress, which affect the lives of American citizens in a host of all-encompassing manners. This vast range of powers taken together confer enough authority to rule the country without reference to normal constitutional processes. Under the powers delegated by these statutes, the President may seize property, organize, control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communications, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways control the lives of all American citizens. Over the course of at least 40 days, presidents have had available by enormous seemingly expanding and never-ending range of emergency powers. Indeed, at their fullest extent, and during the height of a crisis, these prerogative powers appear to be virtually unlimited. Because Congress and the public are unaware of the extent of emergency powers, there has never been any notable Congress or public objection made to the state of affairs, nor have the courts imposed significant limitations. Emphasis added, and whereas the 1973 Senate report also expresses concern that in our current state of emergency, we could end up with a totalitarian state. If the president can create crimes by fiat without congressional approval, and our system is not much different from that of the communists, which allegedly threaten our existence, the enormous scope of powers is a time bomb. Whereas Congress has repeatedly violated its war powers through a long series of unconstitutional acts, resolutions, and other actions, starting with Emergency Banking Systems Act and the Agricultural Adjustment Act of 1933, resulting in massive unconstitutional powers to the president. And whereas the power to both declare and conduct war is thus in the hands of one man, resulting in decades of unjust wars with enormous loss of life expense while being propagandized as patriotism. And whereas the Supreme Court in the Guantanamo line of cases 2008 acknowledged that the U.S. has been under War Emergency Powers Military Commissions Act, depriving the detainees of their constitutional due process, habeas rights, the court preserved judicial review of the constitutional law claims and effectively strengthened standing to state a claim in federal court. Whereas Congress and past presidents have persisted in violating this clause by unconstitutionally sending advisors, troops, and/or money, equipment, and other support to aid foreign nations in wars, conflicts, police actions, and covert activities, including but not limited to Korea, Vietnam, Somalia, Haiti, Kuwait, Kosovo, Iraq, Afghanistan, without a lawful congressional declaration of war as stated in Article 1, Section 8 of the U.S. Constitution. And whereas Congress and the President have engaged in non-defensive military actions by committing U.S. troops in over 130 countries throughout the world, engaging us in foreign entanglements and fomenting animosity and reprisals. And whereas Congress and the President have abused their power by committing U.S. troops to serve as mercenaries in foreign conflicts under the auspices of the United Nations. Therefore, B. Remedial instructions to Congress and the President. Never again engage the United States in any military conflict except for the common defense. The United States must never again engage in a preemptive war. C. Additional remedial instructions to Congress. We demand Congress reclaim its exclusive constitutional power to declare war, repeal all acts, executive orders, and resolutions pertaining to the delegation of any war powers to the President, cease to fund any and all preemptive or offensive military actions throughout the world within 12 months after receiving this document, comply with all of the war powers provisions in the Constitution as originally written and adopted, never again allowing any American troops to be committed for any reason except in accordance with the Constitution, impeach any president who initiates military activity without a lawful congressional declaration of war as stated in Article 1, Section 8 of the U.S. Constitution, return the jurisdiction of National Guard troops to their respective states, enabling the states to revitalize their own militias. Repeal the Emergency Powers Act and their associated provisions in federal court within a 6-month period. D. Additional remedial instructions to the President. 1. Cease and desist now and never again take any military action in any form without a lawful congressional declaration of war as stated in Article 1, Section 8 of the U.S. Constitution. 2. Withdraw U.S. troops from all countries throughout the world within a period of 12 months after receiving this instruction. 3. Instruct all military commanders and leaders to keep their constitutional oath of office by refusing to execute any orders that may result in injury or loss of human life without a lawful congressional declaration of war as stated in Article 1, Section 8 of the U.S. Constitution. 4. Instruct all officers and enlisted men to keep their oaths of office enlisted by refusing to obey any orders that may result in injury or loss of human life without a lawful congressional declaration of war as stated in Article 1, Section 8 of the U.S. Constitution. We also encourage officers and enlisted men to refuse orders to serve under a foreign or international power. E. Remedial instructions to each of the several states. 1. Instruct the U.S. representative and senators to reclaim their exclusive constitutional power to declare war by A. Repealing all acts, executive orders, and resolutions pertaining to the delegation of war emergency powers to the President. B. Ending the funding of any and all offensive preemptive military activities throughout the world within 12-month period after being served with this document. C. Comply fully and strictly with all the war powers provisions in the Constitution as originally written, adopted, never again allowing any troops to be committed for any reason except in accordance with the Constitution. D. Impeaching any president who initiates military activity without a lawful congressional declaration of war as stated in Article 1, Section 8 of the U.S. Constitution. 2. Immediately recall National Guard troops and equipment. 3. Obey the Constitution oath of office by refusing to commit any militia, equipment, or funds that may result in injury or loss of human life without a lawful congressional declaration of war as stated in Article 1, Section 8 of the U.S. Constitution. 4. Protest any military action by the President in any form without a lawful congressional declaration of war as stated in Article 1, Section 8 of the U.S. Constitution. F. recommends civic actions by the people. The Continental Congress 2009 recommends the citizens of each state take the following actions to help resolve the unconstitutional activities of our elected officials. 1. Encourage the people of each of the several states to become further educated and to build coalitions of like-minded people into groups with sufficient numbers to instruct their fellow citizens how to hold their public officials accountable. 2. Get to know your sheriff within your community and determine if he or she will hold public officials accountable to their oath of office. Let them know that you are there to help them and support all lawful effort. 3. With the fellow citizens within your country, county, to conduct lawful citizens' grand jury, which are paneled and conducted according to the state constitution. 4. Participating in unconstitutional war is militarism, not patriotism. In the event of undeclared war, we urge all citizens to avoid supporting or participating in the war in any way, including military service or weapons production. If just 10% of the population refused to fight, the undeclared war would unlikely to ever happen. We the people are the ultimate check on tyrannical government. Article 13, eligibility. I love this section. Amen. My favorite section. Article 13, eligibility and the natural born citizen clause of Article 2, Section 1 of the Constitution, Part 1, a resolution. You know what? I'm going to stop here and let's start a new reading. All right. I've been reading the Articles of Freedom. It's a 63-page document written by the Continental Congress of 2009. It had a lot of contributors, one of which was Schaefer Cox. I'm going to upload this separately, but I'll also be uploading the entire 63-page document, which will probably be over 2 hours. It's quite detailed and very articulate, addresses a multitude of issues with our country, but I have not read this section yet. This section is my favorite section, and I get very passionate about this particular topic, so I thought I would upload this particular topic all by itself. Page 51, Continental Congress of 2009, Articles of Freedom. Here we go. Article 13, eligibility and the natural born citizen clause of Article 2, Section 1 of the Constitution. Part 1, a resolution. A, background and statement of the facts. Whereas the Continental Congress 2009, CC 2009, was convened to defend and not amend the Constitution of the United States of America, and whereas the Constitutional Convention of 2009 has examined, among other things, the constitutional requirements for the office of the President as originally and precisely articulated in Article 2, Section 1, Clause 5 of the Constitution, which says, no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. And, amen to that, by the way, amen, amen, amen. And, whereas the Continental Congress of 2009 finds that Article 2, Section 1, Clause 5 of the Constitution requires a specific class of citizenship to be eligible to hold the office of President, as indicated by the fact that Article 2 includes two adjectives before the first use of the word citizen, but not in front of the second citizen. And whereas the Continental Congress of 2009 finds that Article 2 has not been amended to alter or change these words, nor their meaning, and that no federal court has ruled on the direct meaning of this clause. And whereas the Continental Congress of 2009 finds that until the Supreme Court rules on the natural-born citizen eligibility clause or the Congress and the several states amend the Constitution, the acceptable definition of natural-born citizen is derived from the body of law referred to as the law of nations. Amen. Referenced in Article 1, Section 8 of the Constitution. And, okay, there's a footnote at the bottom of page 51. Let me read the footnote. Footnote 13. Learn more about the subject matter of this article. Read Natural Born Citizen Clause. Read the petition for redress of grievances regarding Mr. Obama's eligibility. Open letter published in the Chicago Tribune on December 1st and 3rd of 2008. Moving on to page 14. Moving on to page 52. Whereas the reference to the law of nations in Article 1 is a direct recognition that the founders respected this body of law, and whereas in writing about the body of law, Emmett Vattel defined a natural-born citizen. To be natural-born citizen means one must be born on the soil of parents, plural, who themselves are citizens. See Emmett Vattel, 1797, The Law of Nations, Book 1, Chapter 19, pages 103 through 104, London. Whereas the Continental Congress of 2009 further finds that the term natural born citizen, as specifically specified only for the office of president, is chiefly concerned that the president have a singular allegiance to the United States of America, and whereas the Continental Congress of 2009 finds that the natural born citizen clause does not establish a superior form of citizen, but instead establishes a national security safeguard against foreign invasion of the White House and takeover of the United States Armed Forces, and whereas the Continental Congress of 2009 finds that the life, liberty, and property interest of Americans could be irrevocably injured, harmed, and threatened should a foreign national or one with split allegiance usurp the office of the presidency, and whereas the Continental Congress of 2009 further finds that no regular or established administrative mechanism exists at any level to ensure the president meets the eligibility requirements of Article 2, and whereas the Continental Congress of 2009 finds that there is immediate need to establish such a mechanism. Now therefore be it resolved. B. Remedial instructions to Congress. In coordination with the several states, establish a regular administrative mechanism and procedures for the verification of the natural born citizenship qualifications and the birthplace of candidates or nominees for the office of the presidency, using original birth certificates, passports, and any and all other identification documents necessary to establish birth within U.S. territories to parents who do not owe allegiance to or other sovereignties. Such procedures shall provide for the verification of all nominees for the office of the president and his successor, and provide for making the determinations available to the public. C. Remedial instructions to each of the several states. The Continental Congress of 2009 instructs the several states to enact legislation to provide for the verification of a candidate for president as a condition for participating in the state general election for president, and to provide for the dissemination of that information to the public. D. Recommended civic actions by the people. The delegates of the Continental Congress 2009, in recognition of the extreme importance of having a constitutionally eligible president, hereby 1. Remind the citizenry that the protection of life, liberty, and property guaranteed under our Constitution depends heavily on an informed public, and that our constitutional republic cannot survive without it. 2. Remind the citizenry that in the 21st century America faces significant security threats, and that it is important to ensure that holders of every elected public office, especially the President of the United States, understand their oath to uphold and defend the Constitution. 3. Encourage the citizenry to study and the attached instructions to Congress and the states and the presentment of the Continental Congress 2009, and to use every tool to ensure for themselves and activate their state legislatures to verify that a presidential candidate is eligible to serve under Article 2 of the Constitution. Part 2, a presentment by and of the Continental Congress of 2009. Resolution raising a question of the Article 2 eligibility of Mr. Obama. Whereas Article 2, Section 1, Clause 5 of the Constitution for the United States says that no person except a natural-born citizen or a citizen of the United States at the time of the adoption of the Constitution shall be eligible to the office of president, and whereas in our constitutional republic, government is an indispensable necessity, and that whenever and however it is instituted, the people must place trust in and rely upon their representatives in order to vest it with requisite powers, and whereas all branches of government in the United States of America have the duty and obligation to protect the people from usurpation and foreign influence, and to ensure that deceptive practices in the determination of eligibility and election of our federal public servants in positions of influence and power are fully and thoroughly investigated, and whereas the framers of our Constitution and those sworn to uphold it have historically recognized that the loyalty of the President of the United States, vested with the supreme executive power and command of our armed forces, be true and faithful, unfettered by foreign ties, attachments, and allegiances, and whereas to allow otherwise affords opportunity to tamper with domestic fractions, practice arts of seduction, mislead public opinion, and influence or all the institutions of government, and whereas the traditions of such constitutional requirement lay in the common belief that the leader of the executive branch of our federal government have the breath of life bestowed in the womb of a mother by a father, both citizens of the United States of America, owing no allegiance to any foreign sovereignty and born on sovereign American soil. Amen. And whereas the definition of a natural-born citizen is derived from the constitutionally accepted and referenced body of law known as the Law of Nations, quoted in the treatise Law of Nations, as those born in the country of parents who are citizens, and whereas a person born of a foreign minister, consul, citizen, or subject of a foreign state would not be solely subject to the jurisdiction of the United States, such persons may possess a divided allegiance, and whereas it is logical that the founders intended to hold the offices of president and vice president to a higher standard of citizenship to ensure no divided allegiance, if the founders intended for native-born citizens to be eligible for these offices, they would not have distinguished this requirement from that of senator. Thus, a natural-born citizen is necessarily a higher form of citizen than a native-born citizen, which may have a divided allegiance. And whereas the people who framed this nation through the Constitution would not entrust their well-being and security to any other type of individual holding such high office, neither shall we, the people, today. And whereas it is unreasonable to conclude that every person born within the geographical territory of the United States is a natural-born citizen, irrespective of circumstances, and that a child of foreigner happening to be born to him while passing through the country is eligible to the presidency, while the child of our citizens born abroad is not. And whereas the purported president of the United States, Mr. Obama, was allegedly born in the state of Hawaii to a Kenyan father who by his own admission was a British subject from the British colony of Kenya, only temporarily residing in the United States as a student. Whereas the citizenship status of Mr. Obama upon his birth would have governed not only by the laws of the United States, but the British Nationality Act of 1948, which by its language made Mr. Obama subject of said British colony, thus with dual citizenship at the least. And whereas a concentrated effort has been made by many, including members of Congress entrusted by the people to protect and defend the Constitution, to intentionally subvert the legitimate and patriotic concern that the current president of the United States is ineligible and disabled under the requirements of the Constitution, which created the office which he presently holds, and is the only position in federal government in which he may not sit. And whereas the judiciary has willfully infringed upon the unalienable rights of sovereign citizens to have constitutional questions resolved by denying standing via technicality of law, and whereas Mr. Obama has been less than forthcoming to those who have continually and consistently requested certain documentation to ensure his eligibility for the office of the President under Article 2, and whereas Mr. Obama, on the contrary, signed Executive Order 13489 claiming executive privilege, blocking the release of personal documents by the National Archives and Records Administration immediately following his inauguration, and further has expended large sums of public money to pay for attorneys necessary to frustrate those who simply wish to ensure that our President is eligible for the office he holds under the Constitution for the United States. And whereas Mr. Obama, with respect, has engaged in conduct unbecoming of the President of the United States, in which reasonable doubt can be raised to his fidelity to the United States. And whereas the delegates of the Continental Congress 2009 believe the people, regardless of their level of support of Mr. Obama, are interested, desirous, and in need of a resolution regarding the eligibility of Mr. Obama under the Constitution for the United States. Therefore, be it resolved that the delegates of the states participating in the Continental Congress 2009, 1. Call upon the state and federal judges, Congress, and any others with appropriate power, authority, and jurisdiction to uphold your oath to the Constitution and investigate to the fullest extent of the law, power, and authority invested in you the truth concerning the natural-born citizenship status of Mr. Obama, and 2. Order a grand jury investigation of the matter of Mr. Obama's eligibility and the prosecution of any who may have committed fraud and or conspired to commit fraud, and 3. Remove Mr. Obama from the office of President according to the constitutional provisions available for such action, should it be discovered in truth and substance that Mr. Obama is not a natural-born citizen. Amen, amen, praise God, and amen. Wow, powerful, powerful stuff. Okay, let's continue with page 55. We got to get to page 63 to the end. Article 14, illegal immigration and the oath of office clause of Article 2, Section 1, and faithfully execute clause of Article 2, Section 3 of the Constitution. Learn more about the subject matter of this article. Read the oath of office and the faithfully execute clauses. Read the petition for redress of grievances regarding the failure of the President to enforce the immigration laws. See the related Continental Congress 2009 video presentations. Jeff Lewis, National Director of the Federal Immigration Reform and Enforcement Coalition, FIRE. Introduction, Corey Voris and John Sampson, former agents, Federal Immigration and Custom Enforcement, ICE, Border Realities, Drug Wars, Silver or Lead, film. Page 56. The Constitution of the United States of America is being violated. It has been violated over many years by many administrations, by every branch of government, by each party. Pursuant to the First Amendment of the Constitution, that we, the people of Foundation, submitted petitions for redress of grievance not once but twice in June of 2008, again in August of 2009, which were duly served on all members of the Congress and the United States government and the President. Find attached documents A and B. The recipients included the President, responded only with silence. Under these facts and circumstances, it is well settled in American jurisprudence that silence is an admission. By its silence, the government has admitted to its violations of the Constitution. Wherefore, we the people now find the government to be in violation of the Constitution in the manner as described below. We the people do hereby declare the following. A. Remedial instructions to the President. Whereas the executive powers are vested in the President of the United States of America, whereas the President must take an oath of or affirmation before executing his office, whereas pursuant to Article 2, Section 1 of the Constitution, the oath or affirmation reads, I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will to the best of my ability preserve, protect, and defend the Constitution of the United States. Whereas the people have served their government officials with petitions for redress regarding the failure of the government to execute the immigration laws, only to have those petitions ignored. Whereas Article 2, Section 3 of the Constitution requires the President to take care that the laws will be faithfully executed. Whereas in May of 2007, on the floor of the House of Representatives, Rick Keller stated, it is estimated that there are currently more than 20 million illegal immigrants in this country. The cost of illegal immigration to our healthcare system, public education system, prison system, and social services continues to rise without any sign of stopping or slowing. Whereas the presence of no less than 20 million illegal aliens in the United States is self-evident that the immigration laws are not being enforced. Definition. For the purposes of Immigration and Nationality Act, any person who is not a citizen or national of the United States, there are different categories of aliens: resident and non-resident, immigrant and non-immigrant, asylee and refugee, documented and undocumented, illegal. Additionally, according to the Immigration and Nationality Act, an alien is an individual who does not have U.S. citizenship and is not a U.S. national. The INA defines a national of the United States as one who, while not a citizen, owes permanent allegiance to the United States. One owes personal allegiance to the United States if that person has taken an oath of naturalization. Cornell University Law School. Whereas among the laws not being enforced are USC Title 8, Section 237, Section 1324, and Section 1325, Article 4, Section 4, which reads, the United States shall guarantee to every state in this union republican form of government and shall protect each of them against invasion and on the application of legislature or the executive when the legislature cannot be convened against domestic violence. Whereas the failure of enforcing these laws has cost the nation hundreds of billions of dollars in the last decade alone and have put the nation at risk of terrorism, crime, and disease. Therefore, we the people instruct you to fulfill your sworn responsibilities as President to commit the necessary resources to faithfully execute all the current immigration laws. B. Remedial instructions to Congress. Whereas current statutes prescribe the various penalties for violations of the immigration laws, among those penalties are deportation, which is found in 8 U.S.C. 1227 and INA 237. Anything less than the application of these statutory penalties would constitute a forgiveness of civil penalties, and whereas the effect of the President's failure to fulfill his duty has resulted in great cost to the nation due to undue strain on society and the economy in the form of terrorism, crime, disease, there also results in the blurring of the distinction between legal and illegal immigration, which penalizes those who have gone through the naturalization process lawfully. Therefore, be it resolved that Congress shall remind the President that by whatever means necessary of his mandated duty to take care that the immigration laws be faithfully executed as mandated in Article 2, Section 3, Paragraph 1 of the Constitution, and 2, Congress shall appoint an investigative committee for the purpose of determining whether the President has faithfully upheld the Constitution in accordance with Article 2, Section 3, Clause 5. 3. If the President fails to fulfill said obligation cited above after the instructions from Congress by default, he has violated his oath of office as under Article 2, Section 1, Paragraph 8 of the Constitution, and it can be subject to impeachment of proceedings in criminal or civil action. Number 4. Congress shall not enact any legislation that provides social services of any form of amnesty for illegal aliens. C. Remedial instructions to each of the several states. Whereas the President has demonstrated his failure to faithfully execute the current immigration laws, specifically 8 U.S.C. 1227 and INA 237. Whereas the President and the executive branch of the federal government have failed to enforce the aforementioned immigration laws, whereas state law enforcement officers must take an oath or affirmation to faithfully execute the Constitution and application and applicable laws enacted thereto. Whereas the United States versus Santana Garcia 264 F3D 118-1194 citing United States versus Vasquez-Alvarez 176 F.3D 1294-1295, a United States Court of Appeals upheld the right of the states to enforce the federal immigration laws by stating state and local police officers have implicit authority with their respective jurisdictions to investigate and make arrests for violations of federal law, including immigration laws. Now, therefore, be it resolved that 1. The governors of each state shall direct the law enforcement officers of their state by whatever means necessary to honor their oaths of office and to take care of that immigration laws be faithfully executed to the fullest extent. And 2. The legislation of each state shall take steps to sanction or impeach the governor and or law enforcement officers who fail to honor his oath of office or otherwise fails to fulfill his obligations to enforce state and federal immigration laws. D. Recommended civic actions by the people. We, the Continental Congress of 2009, declare that the President of the United States of America has failed to take care to faithfully execute the laws, and we encourage the people of the United States in their legitimate capacity to engage in the following civic actions. 1. Educate yourself, your family, and your community about your government officials' duties and all the current immigration laws. 2. Meet with your county sheriff and ask him to execute the current federal and state immigration laws for which he is authorized. 3. Lobby your state legislature to demand your state governor to execute all the current immigration laws where applicable. 4. Lobby your congressman to bring impeachment proceedings against the President of the United States of America by failing to assure execution of all current immigration laws. Article 15. Ancillary report by the Foreign Policy and General Welfare Committee regarding the welfare state. Whereas the mention of general welfare in the preamble of the Constitution for the United States as the principal goal of the Constitution conveys no specific powers to government, and the General Welfare Clause of Article 1, Section 8 of the Constitution for the United States is only intended to be restricted to the enumerated powers which follow it. And whereas James Madison states in Federalist 441 that nothing is more natural or common than to a general phrase and then to explain or qualify it by a recital of particulars, and it would be an absurdity if the list of particulars was interpreted as anything but restrictive on the general statement. And whereas the early 19th century serves as an example of rapid economic growth despite very limited government investment in the general welfare, and during the period of institution of the family provided adequately for most Americans without any federal welfare, and voluntary religious and charitable associations flourished without government involvement. And whereas the family and the state are competing forms of government with the result that when one is strengthened, the other is weakened, and the family is the most effective provider of social services, so that the general welfare is best served by strengthening families than by strengthening government. And whereas the responsibility of government is to secure its citizens to the fruit of their labor, which is their property, and the opportunity to utilize that property as capital to create wealth. Therefore, the delegates of the several states in Continental Congress assembled 1. Protest this misinterpretation of the General Welfare Clause by Congress that results in the tyranny of unjust taxes upon the people. 2. Find the general welfare is neither promoted nor provided for when Congress exceeds the enumerated powers of the Constitution, and the General Welfare Clause does not provide constitutional justification for bullet, mandated or government to run health insurance, Social Security, Medicare, Medicaid, or any form of welfare payments to the individuals, but those who were forced to contribute to any of these programs shall be reimbursed less any payments from those programs that may be received, inflation, and to be accounted for in the calculations of amounts due. Bullet, mandatory vaccines, mental health screenings, or collection of medical data of individuals. Bullet, the violation of the right of individuals to decide which food, substances, or medications they put into their bodies. Bullet, bailouts, grants, loans, investments, or any other form of corporate welfare. Bullet, the disguised regulation of private activity through subsidies. Bullet, grants to churches or other religious charitable organizations for any purpose. Bullet. Federal funding of education at any level. Bullet. The coercion of states and municipalities to adopt national standards by threatening to withhold funds. Bullet. The building of infrastructure except as enumerated in the Constitution. Bullet. Economic stimulus grants, bans, or any other appropriation for state and local governments except as enumerated in the Constitution. Bullet. Any other federal law, statute, or regulations that is not specifically enumerated in the Constitution. The assistance and protection of divine providence. Whereas America's Declaration of Independence contains essential principles underlying the greatest governing documents ever given to mankind, and whereas among our essential principles is the belief that we are endowed by our Creator, nature's God, with certain unalienable rights, and the governments are instituted among men to secure these rights, no more, no less, and whereas the maintenance of these principles depends upon a firm reliance of the protection of divine providence. Therefore, we, the delegates of Continental Congress 2009, recommend the following actions to be taken by the people. 1. Each of us, beginning with ourselves and our families, set apart a day of fasting, weekly, monthly, or whenever, to appeal and to meditate and pray for the blessing of divine protection, providence in guiding our steps and assisting us in our struggle against the enemies of liberty and reclaiming our freedom, and to encourage our friends and neighbors to do the same. 2. Encourage your minister, priest, rabbi, or other religious or spiritual leader to lead their congregation in a monthly day of fasting, meditation, and prayer for the blessing of divine providence to guide the success of our efforts. In respect to our founding fathers recorded in the founding documents in the God-given rights of life, liberty, and the pursuit of happiness to every citizen. Without life, there is no liberty or pursuit of happiness. Nationwide civic action. Delegates to the Continental Congress 2009 and others from each of the several states shall serve the document titled Articles of Freedom with its remedial instructions on each United States Senator, Representative, in their offices located in their respective states, placing them on notice that we, the free people of America, believe them to be in violation of their oath of office and the Constitution for the United States of America. Below is a pledge to be signed by individual Americans, signifying their belief that A, for decades and over many administrations, both political parties have been violating the Constitution and the states have acquiesced. B, the Articles of Freedom should be served on key elected officials in the federal government and all 50 state governments. C, the federal and state officials should comply with the remedial instructions designed to put an end to the violations and restore constitutional governments. D, if the government officials refuse... Hey babe, will you answer? The federal and state officials should comply with remedial and instructions designed to put an end to the violations and restore constitutional governments. If the government officials refuse to comply, the people shall engage in a nationwide, well-organized, proactive, nonviolent series of civic actions, including economic sanctions, if ultimately necessary, to peaceably procure the relief they are entitled to under our system of governance. Pledge. In the full view of the Creator as my witness, I hereby pledge my signature and vow to join with a goodly number of millions of Americans to hold our elected and appointed officials accountable for all their violations, with a firm reminder that each one has sworn an oath or affirmation to preserve, protect, and defend the Constitution of the United States of America. In seeking to hold them accountable, I shall hold myself accountable to do the same. I renounce and condemn any and all initiation of violence, force, and will pursue all lawful and constitutional means to fulfill my duty. When a goodly number of millions of American people agrees, we will act in a lawful and constitutional manner until all violations of the Constitution for the United States of America cease. I place my name and shall participate as an eternal record of the will of the people to be free. Let's see if Schaefer's name is on this. We have Illinois, Montana, Nevada, Maryland, South Carolina, North Carolina, Texas, Wisconsin. Looks like Alaska didn't make it down there. But I did hear he was presenting the Articles of Freedom to various congressmen. That is on his website. All right. Anyway, that's a very good document. Let's get it uploaded.